That's common. That's what we did with Sanchez. I believe it. No, yeah, not really. It's every Solis or Argo without.
All right, everyone, happy Monday. It's going to be a great week. And I think it's going to be a great week because next week is spring break. And we will not be here during spring break because I think people should have a chance to spend time with their families. And if you have children who are in elementary school age, this is the only time you're really going to get to be spending spring break with them, because once they're in high school and in college, they may not want to spend spring break with their parents. So I'm going to call the docket. Let me know you're here. If you don't answer the docket, I'm going to assume you're not here and a warrant may be issued for your arrest. Herbert King. Thank you. Kayla Rolack. Nicholas Ornelas.
I'm so sorry.
Oh, that's okay. What music is that from?
Just the regular ringtone.
Okay. Christopher Barode. Christopher Barode. Am I pronouncing his last name correctly? Jesse Jason Gonzalez. In custody, we have Travis Molden, Melvin Jones, Epifano Marcada, Mark Sauceda, Armando Mata, Jesus Solis, Raul Lucio.
Where are you? You stand up.
Ronald Keith Collins Jr.
Good morning, I'm here for him.
Okay, and I see you're going to add something to your announcement.
We're going to be enjoying spring break in the great state of Louisiana.
Okay, what part of Louisiana?
Down in the French Quarter.
Oh, wow. So you rather say French Quarter instead of saying New Orleans?
Collins.
Yeah.
Well, I mean,
Okay.
we did contact Mr. Collins, Judge, have not heard back. I don't know what to tell you at this point. I anticipate he will be here.
Okay.
May I be excused to call my office and then announce it in another court?
Yes.
Thank you, ma'am.
You're welcome. Abel Ornelas is in custody. Lacey Rivett. Thank you. Is this S. John Smith or something? John Ray Smith? It's not listed on the docket. Is there a Mr. Smith here? In custody, we have Sean Chrisman, Rolando Garza, Robbie Gonzalez.
President Council, Judge, we're ready.
Thank you. Donald Stockton, custody. Jesus Solis, Jacob Guevara, custody. Mariah Rodriguez. Francisco Reyes.
President Council.
James Brooke will be back on March 9th. So if there's a James Brooke here, Brooks here, you'll be back on March 9th. Mark Anthony Salmon is in custody. Lisa Marie Garza. In custody, we have Tyler Small, Margaret Roberts, Jose Gallegos. Thank you. In custody, we have Bobby Tracy, Sarah Espinoza. In custody, we have Caleb Ruiz, Dean Villarreal, Javon Crockett, Anthony Ruiz, Derrick Reyes.
President, council's president, and I'll confer.
All right. Thank you. Ralph Delgado, Patricia Perez, that's at 11. Paul Donaldson is in custody. Michael Montoya, custody. Ignacio Rios. Thank you. Gerald Wilkerson, Jorge Diaz, Ronald Rodriguez, Gaspar Rodriguez, Jason Lopez in custody. Ronald Rodriguez, let me see. Felix Apolinar.
Good morning, and I'm here.
All right, thank you. All right, everyone, is there anyone here whose name was not called or you came in late? Oh, that's a first. All right, these are the rules of the court. Try to keep the courtroom as least congested as possible. Spring break is about to happen. I know no one wants to give the flu or pneumonia to their child. So this is the way it works. On this side is criminal trial division. On this side is family violence. They have files on either side. Just grab the file, place it on their table, have a seat. They're going to call you in the order of appearance. First will be first, last will be last. The only exception to that is if someone needs an interpreter. If you have a client who speaks another language or feels more comfortable not speaking the English language, they will need an interpreter. You need to have that interpreter called down, whether you speak their language or not. If you have a client in custody, you need to confer with that client. Do not approach the court if you have not conferred with the state and conferred with your client. If your client is in custody, you need to confer with your client. Do not approach the coordinator for a continuance or a reset. I'm the only person who can give you a continuance. I'm the only person who can allow you to reset. So, as you can see, the courtroom is slightly clouded. It's Monday. It's going to be a beautiful day. If we make it a beautiful day, put some patience in your pocket, take it out as needed. To the guys, I know you have a hidden pocket in your suit coat jacket, so pull out that patience if you're needed. All right, everyone, please confer. Good morning. Hey. Oh, no, that's fine. It happens. Oh, my phone tends to ring, so it's fine.
Yes.
Number 23. Straight.
She mentioned not in prison, but
Yeah.
That post judge?
After I have a file. Oh,
Chrisman. I'm sorry.
all right. Who's here on Robbie Gonzalez?
I am, Your Honor. Mr. Gonzalez is present.
All right, Mr. Gonzalez, if you'll come forward.
It's not on my
All right. All right, everyone, please whisper. All right. What is happening with this case?
Your Honor, the doctor's report came back from my client. He is competent and ready to stand in trial, and we're announcing ready.
All right. Have you conferred with the state?
Yes, Your Honor.
Have you tendered an offer?
There was an offer previously.
Yeah.
All right.
Rejected.
All right, Mr. Gonzalez, are you rejecting the state's offer?
Yes.
Are you requesting a jury trial?
Yes.
All right, Mr. Gonzalez, your plea deadline date has expired. The court will not accept any plea bargain agreements in this case after today without good cause. Otherwise, you're going to have to plead open to the court. Do you understand what that means?
Yes, ma'am.
All right, so your attorney keeps shaking his head, yes. So I need to know from your client if he understands.
You understand?
Do you understand?
Yes, I do understand.
All right, and do you understand about the court's plea deadline date?
Yes, ma'am.
All right, so did you receive an offer from the state?
Yes, I did.
All right, and are you rejecting that offer?
Yes, ma'am.
Okay, all right. Ms. Ferguson, this is this is family violence. I need a jury trial date.
I can do it first.
Perfect. But do you have a Monday? The mother is the one from Florida coming in too. If we have to do Monday, we do Monday. I guess we pick on Monday or.
No, what ends up happening is jury selection is on Tuesday.
Oh, perfect. That'll work.
Yes.
Perfect. Okay.
All right, so you'll be back on April 3rd for jury trial.
Very well.
All right, let me see the indictment in this case, just a moment. All right, and who is his mother?
Elizabeth Brower.
Okay. All right, thank you. Is there anything else from either side?
Nothing from the defense show.
All right, Mr. Gonzalez, do you have any questions for me?
No, ma'am.
All right, thank you. Thank you for dressing appropriately for court. I appreciate that.
I'm sorry. Impact weakness, so I might do this.
All right. All right, so your case may end up being sent to impact court, which means I will not be the judge who's hearing your case. Another judge will hear it, okay?
Very well, Your Honor.
Yes, ma'am.
All right, you can give them a reset form for April 3rd.
Thank you, Your Honor.
You're welcome. And Mr. Smith, did you have the order from the other court stating that he's competent?
All I have is the report. We did not reach. I don't think that's been done yet.
All right, so that needs to be done in Judge Carruthers' court.
Okay.
Ms. Ferguson, can you make sure that that's done before April 3rd, that he's legally declared competent in Judge Carruthers' court?
Very well, Your Honor.
All right, thank you.
Thank you.
Yeah. I think you do that.
That's your indictment.
All right, Sean Chrisman.
Morning, Judge. He's in custody, but he's at University Hospital. I was hoping to have him over here, but we've got a deal, I'm sure, worked out. So if it's okay with you, I'll keep track, and as soon as he can be released back to county.
Okay, why is he at University Hospital? Does anyone know?
Pardon me?
Why is he at University Hospital?
Oh, he's been there for about 2 weeks. He was having seizures and they
Okay.
took him. But I got a message from the hospital this morning that he's on oxygen and they don't want him to release him without the oxygen at this point.
Okay. All right, so Mr. McCrum will depend on you to keep us updated. All right, Ms. Ferguson. On Chrisman, I need a reset date for 3 weeks, please.
Very good. I'm definitely gonna be trying to get him in before that. If that's
Okay.
okay.
We can't do the week of March 27th. There's no date available that week.
Okay, Judge, I'll put it for March 30th.
All right, is March 30th okay with you?
Yes, Judge.
And then if he is still at the hospital, we'll know. I just don't want this to get dropped.
Right.
All right, we'll see you back on March 30th.
Thank you.
You're welcome.
It's sentencing that on the message to be public for Thursday. Thank you.
Herbert King.
Hey, Sandra.
All right.
Your Honor, the party record is Monica Guevara. She had federal court in Del Rio this week. She returns Thursday. Mr. King has already pled. Sentencing was today, but Monica's asking if you could recall it to Thursday so that she could do the sentencing with Mr. King
All right. And you said she's in federal court?
in Del Rio, correct? And as soon as she gets back is Thursday.
All right, Ms. Ferguson, on Mr. King, let's recall that.
Is Thursday a problem?
I'm not going to be here on Thursday.
I was not aware.
Yes. So. Yeah, there are medical appointments scheduled, so that's why I won't be here.
If perhaps Mr. King could be excused and I get a court date with Norma. I'm here for Joanne Doris.
Okay.
I'll be here all morning.
Okay, so I tell you what, let's do this. Let's tentatively put it for March 27. Ms. Ferguson, can we put Mr. Herbert King? Do you all have witnesses or no?
Straight the other way, right to the right to the left.
I did not check with the states and Mr. King was in.
Well, the state is silent.
At this time, maybe just one person, an employer perhaps.
Okay. All right, Ms. Ferguson, are we able to put this on the 27th? All right, so we'll bring it back on March 27th.
Thank you, Judge.
Just get a reset form.
I will, I could inquire, I believe Mr. King had brought to my attention the last time when he pled. And I do recall that, I believe you had asked Monica to file something to the effect that you were going to permit him tracking. I don't believe something was filed, but he's asking if you could grant tracking at this time.
All right, if you'll follow it, then I'll hear it.
Together. I'll follow it. If you could sign this here.
Are you okay?
Now I'm not waiting for Joanne to unless she has a.
Morning, Judge, may I approach?
Good morning. Do you have the file?
I've got the state's file.
No, I need the court's file.
On this was some.
Everyone, when you're approaching after you finish conferring, just ask the clerk to give the court the file. And once the file is placed here, just have a seat. I'll call you up in the order of appearance. Jesus Solis.
Morning, Judge.
Good morning. And where's Mr. Solis?
He's in the box.
All right, he needs to come down. Right, what is happening with this case?
Judge, I have filed 2 requests to have my client evaluated, one on each of his cases. Just to see if he's fit to stand trial. The reason is, I talked to his family in preparing for trial. And they indicated that he's a schizophrenic and he's supposed to be on medication. And that he's been institutionalized 2 different times. So just out of an abundance of caution, I thought I'd have him evaluated. That and some things he said, maybe ask the family in the first place.
All right, so you think he's not competent?
I think he might not be, yeah. So I just want to make sure, if we're going to trial, I want to make sure that he's on medication, he's supposed to be on medication.
All right, have you filed your motion?
I did, Judge, on both cases.
All right, Ms. Ferguson, I need a reset on Mr. Solis.
And if you'd like, I have the copies of the motions here, Judge.
Oh, well, they should be in the system.
They're from the file, but yeah. I
Okay.
went in the back and got them for you.
All right, well, make sure that let me see.
And the order is attached as well on each.
All right, thank you. All right, Norma, on Jesus Solis. Because I'm assuming this is going to be someone who's appointed to evaluate him.
Yes, Judge.
All right, can you send an email to Judge Carruthers Court and let them know that that the court is ordering a competency evaluation? And there's no need for an informal inquiry. Here, our counsel. And what date are we coming back on Mr. Solis?
Want me to give them 30 days?
Yes.
I can do April 3rd, April 6th.
All right, we'll be back on April 6th. Mr. Solis, do you have any questions?
No.
All right, thank you.
May we be excused, Your Honor?
Yes.
Thank you.
Who's here on Jason Gonzalez? And if Mr. Jason Gonzalez can come forward? He's not present. He's a fugitive.
Yes, Judge. I haven't had any contact. I think it's she actually.
Okay,
I'm not sure. I'm not, I think that's how you normally spell Jesse when it's.
Jason?
yes.
Oh, well, then I don't know.
All right, Norma, if you can give me another 30-day reset on Mr. or Miss Jesse Gonzalez, please.
I can do April 6th.
All right, we'll see you back on April 6th. We'll see if they're picked up.
Thank you.
John Smith.
Discharge, good morning.
Good morning. Where's your client?
He's not here, Judge. I do have some, he did get discharged. He had a heart attack. He's got a plethora of health issues. I'm hoping that,
So is he on a surety bond?
I believe so.
All right. Have you called the bondsman
No,
to see where he is?
I believe he's at home.
He needs to be here.
I'll try to get him in, Judge, but he's very incapacitated.
Well, I need some proof of that.
I have some, how do I provide it to you? I've got his discharge paperwork. I guess they could roll him in here in a wheelchair if you wanted to.
Oh, yeah, sure.
Really?
Yeah, I mean, if he wants to come in a wheelchair, we've had people come in wheelchairs, but I need documentation, something that says he can't be in court.
Okay.
Because this case has been going on since January, and as far as I know, it's been reset. A bond was set for him in January, and the court has not seen him. An acknowledgement of discovery was filed on January 27, 2023. But yeah,
He was here that day.
okay, yeah. He needs to be here. I need some documentation from a doctor saying that
Okay.
he cannot be here.
Fair enough, thank you.
You're welcome. Jacob Guevara, is he in custody? And Norma, what is the update on his psychological evaluation? Deputy Mejia, if you get a chance, could you bring up Mr. Guevara briefly? Thank you. It has here from September 7, 2022, psychological evaluation. Defense attorney to file motion. And who is the? And yeah. And this psychological evaluation was supposed to have been done in September. Yes.
Morning, Judge. I like your glasses.
Oh, thank you. And my brother is with my mom, so I'm receiving texts, and she's like, "Tell everyone I said hi." So. Lisa Marie Garza.
She's present, Judge.
you doing this morning?
I'm just excited to be here.
Okay, that is from Big Trouble in Little China, where he said, I'm just happy to be alive.
I'm gonna take credit for it.
Okay. You know, Big Trouble in Little China was an underrated movie.
I remember that. I think we're dating ourselves.
We are. But that's okay. Now everybody's doing our movies again. They're just doing it as a reboot.
And not very well.
No, they're not. All right, let me see which page Miss Garza is on. All right, so what is happening with this case?
Judge, you had reset us. The state was looking for two items, one surveillance footage from I think a restaurant across from my client's house that may have had footage, and apparently they checked, and the surveillance footage they checked doesn't show anything, just the cameras weren't pointing at anything. But then Jason said he emailed the detective about some reports about prior incidents
Yes.
between the complainant's family and my family, but he hasn't responded. The detective hasn't responded yet.
So when?
I can follow up again, Judge, with the detective, but he hasn't replied to me from a couple weeks ago.
All right, so on February 6th, we were here for discovery. Video, if it exists, which I'm being told it does not exist. And then prior reports between the parties. And so we're still waiting on prior reports between
Yes.
the parties?
Yes, that's far. He hasn't, I don't know. I know he has some way to check for past incidents from particular addresses, but he hasn't, as far as I know.
And Judge, we know they exist because the complainant's sister had a no contact order. She was not supposed to trespass or contact my client's family based upon some prior incidents, but I don't have any offense reports, and that's what we're trying to find out, whether or not the brother was mentioned as well, the decedent.
And I'm sure you do not wish to proceed without having that documentation. All right, Ms. Ferguson, I'm going to give you all 3 weeks. And if you don't hear from that officer, then he needs to be subpoenaed for a hearing to find out where the reports are and if they exist and why Mr. Maurer doesn't have those. All right, what date? All right, so we're going to come back on March 30th.
And Judge, I conferred with the state about the GPS, and we can't come to an agreement about removal. So I'd like to see if you can refer me to either Judge Carruthers or Judge Nahara for a hearing.
Okay, all right, we'll refer you to Judge Nahara. For some reason, they have moved Judge Carruthers' court. Nobody was informed. They just told him, I think, on Friday, you're moving on Monday.
Like from where he's always been, he's not there anymore.
No. So somebody who knows have decided to give him a courtroom that there is no space for a court reporter. So the court reporter won't have an office. There's really no space for clerks. Again, I always tell people before you make decisions, like walk the building.
Well, the Impact County Court offices don't have telephones, so that tells you about how Bear County works.
All right, so we'll come back on March 30th.
I thank you, Judge.
And then Ms. Ferguson will give you a reset form. And then if Judge Nahara can't hear it, then I can hear it.
Okay, I'll go check with them.
Thank you. Jacob Guevara, we're still waiting for her to come back on that.
He's up here, Your Honor.
Jacob Guevara, if you could come down, please. Hello, Mr. Guevara.
Hello.
Hi. Oh, you have it on backwards. Are you turning it on backwards because they are making you use the same one over and over?
No,
Yeah, it goes the other way.
like
Oh, okay. All right. All right, Mr. Guevara, your attorney is in jury trial in 379. Has a doctor or anybody come to see you?
no,
All right, are you on any type of medications at the jail?
No.
All right, Ms. Ferguson. I need this recalled back in 3 weeks. All right, we're going to bring you back on March 30th. Your attorney should be out of jury trial by then. Okay, do you have any questions? All right, we'll see you then. The deputy is going to take you back, Mr. Guevara. Just 1 second. I believe I do. Yes. Ornette, right?
Yeah.
Okay, I have that. I just have. All right.
I read the drug.
Okay, let me see if I have 90. I have 9214. Okay, let me see.
The same offense. For whatever reason.
Okay, Caroline, I have 9214. Yeah. It's disappeared.
Public service stuff. For the mask. We go to a desk. That should be around.
Diana. Diana.
We are.
Oh, no, no, no. We can speak first.
Yeah, I'm gonna be here.
I will call you.
I'm the 27th. Yeah, I'm getting ready to work.
Oh, no, I'm good. Yeah, I don't know where it's going. I mean, is this a sign that blue file was torn up so badly it needed to be returned?
Those motions were in there, I'm not sure.
I'm serving on the harassment you done for drugs. Okay. Print it up. They have them bring them out. Molden. Well, yeah, Jason, let me talk to him. I mean, my last thought was.
Hello.
How are you?
All right, how are you doing?
Very well, thank you.
Are you headed on any trip anywhere?
No, my son's coming to town, so I'll just stay here with him.
Oh, well, that'd be nice.
Yes, I'm looking forward to it. Put it up there, okay. That's fine.
Well, when I review TPS, if I see anything that I think we need.
Felix Apollinar. Hello, good morning. What's happening with this case?
On this one, Judge, there was a notation that Mr. Fulner was trying to retain counsel, but I don't think he was able to do that.
All right, Mr. Apollinar, did you retain an attorney?
No, I did, man. Want to keep it sure.
All right, so has an offer been tendered?
Judge Defense hasn't confirmed this just yet.
Oh, well, you all need to confirm.
We're waiting on the file, Judge, but
Okay,
so as soon as we get it, we can get some.
all right, thank you.
Thank you. Take a seat.
And I'm gonna go to another. How long will it take?
Zach. Muddy that water. Muddy that water. I don't know all of this. Yes. We were just discussing our upcoming nuptials. March the 28th. Hey, you, me and Mary Diaz. Yes. Thank you. Today? March Madness Survivor Pool. You don't know anything about squares either, but you won that.
Yeah, but I have a finding. I would like you guys watching.
I bet Chewy did it. Remember Chewy? Of course. I put on one of those. I put on one of those yesterday. Are you going? I go, yeah, I will be for sure. You know, some are supposed to go, but it's not about there. I was gonna think years ago, which day? Which day Thursday? It's the best time. Academic year. For Donaldson has 18th birthday, so this year's 21st birthday, so I'm trying, but yeah. And this guy told me, I got you, but I told him I have it in my hand. Those are the ones that like bring back every day. It's like you have to bring back every day. Yeah. So, I'm not 100% convinced. I have airplane tickets stuff just in case, but I'm not. I'm telling. I'm right on that. I mean, I would love to go. If you haven't been, you need to. I don't know. I would love to go. I'm not talking about it like going to church. It's whatever. Oh, Lord. Haven't been in.
Oh, Lord.
I was in misdemeanor prosecuting. You called me on those.
And Kelly is not an absolute gentleman.
Francisco Reyes. Who's the attorney for Francisco Reyes?
You have to step out, Your Honor.
All right. All right, just have a seat.
Okay.
We have established contact with my client, Mr. Burrows. We roughly hang up on that. No. I'm just letting you know. I anticipate there's a decent chance he'll show up. And if he does, can you let me know? I have a large. I think Mr. Conley. Yes, that issue notwithstanding.
Anybody that's an outside.
I'm here on.
Melvin Jones.
There's something.
Okay, I thought it was. Yeah. He's a trial. No, well, yeah, I'm gonna tell the judge that. So I can bring the client. I don't know anything about
Well,
that, but anyway. I don't know.
We've already called.
Kayla Rolack.
Excuse me, did you say Rivett?
Kayla Rolack.
Oh, I'm sorry.
Who's the attorney for Kayla Rolack?
Right here, yeah.
Thank you. Sorry. All right, I need everyone to please whisper.
I need you to treat me.
All right, who's the prosecutor? All right, court is calling. And I need everyone in the box. If you're behind the court reporter, please do not speak because she needs to be able to hear. Court is calling 2022 CR 9351, State of Texas versus Kayla Rolack. Could I have parties announced for the record for the state,
Attorney Mitchell for the state.
for the defense?
Albert Rodriguez.
And are you Kayla Rolack? According to the plea bargain agreement in this case, you pled to the lesser included offense of abandonment of a child with intent to return. Punishments to be assessed at 2 years in the state jail facility. There's a $1,500 fine. The state is opposed to your application and they're taking several cases into consideration. Have both parties had a chance to review the PSI report?
Yes,
State?
Your Honor.
Your Honor, I don't know if I. Yes, Your Honor.
All right, any objections to the PSI report, defense?
Other than it says that she's unemployed, she is employed.
Okay, any other objections than that?
No.
All right, state, any objections to the PSI report?
No, Your Honor.
All right, state you are opposed to the application. Do you have any witnesses?
We do not, Your Honor.
Defense, do you have any witnesses?
Yes, Your Honor.
All right, defense, you may call your first witness.
Is that okay?
All right, can you raise your right hand? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth so help you God? All right, I'm gonna need you to speak up.
Okay.
All right. Could you state your name for the record?
Cynthia Cisneros.
All right, and could you spell it for the court reporter, please?
CYNTHIA, last name Cisneros, CISNEROS.
All right, off the record for a moment. And Norma, if you could tell the attorney, the interpreter is here. So whenever they're ready to proceed.
He's right there.
All right, counsel, because we have a shortage of interpreters, if I could take
Yes.
take this matter up very
Go
quickly.
ahead.
All right, thank you. I appreciate that. Jorge Diaz. Good morning.
Good morning, Judge.
It's always great to see you.
Likewise, Judge.
All right, what is happening on this case?
Judge, I've conferred with the state. There's still some discovery that I need to obtain from them.
All right, what discovery is it? Because the court has that on January 26th, a discovery acknowledgement was signed and filed. So what discovery is outstanding?
Judge, there's the child safe interview. And I understand the state now has copies of the polygraph that was given to the defendant.
All right, State, do you have that?
We do, Your Honor. He just needs to make an appointment to view the child safe.
All right, and then the polygraph?
Polygraph, we can prepare copies for him. They're in the file.
All right, can you give that to him today since he's here?
Yes.
All right.
I'll get that.
All right, anything else?
No, Your Honor.
Has an offer been tendered?
An offer was tendered today.
All right, Ms. Ferguson, I need a 3-week reset. You can put this in April. It'll be for a plea deadline date. All right, April 6th will be your plea deadline date. You'll need to let the court know whether or not you're accepting the state's offer. After that date, the court will not accept any plea bargain agreements with not good cause. Otherwise, you have to plead open to the court. Do you understand?
Yes, Your Honor.
All right.
Yes, Your Honor.
And then has he already received the immigration information?
Yes,
Okay. So that's completed.
yes.
All right, thank you.
Thank you, Judge. May we be excused?
Yes. Yes, thank you so much. Melvin Jones. Yes. All right, is there any issue with his clothing exchange?
Judge, I'm appearing for Robert Porter. Mr. Porter is currently picking a jury in the 227th District Court.
All right, let's see where that goes. We'll
Okay.
have him come back tomorrow and we'll see if he's still in jury trial or not.
Sounds good.
All right, thank you.
All right, thank you.
All right, Nicholas Ornelas. Can you come forward? Where's his attorney, Norma? Okay, so when are we calling this back? No, I mean, what is the attorney's illness? All right, so if we can find out. Because I don't want to call him back for tomorrow and then his attorney is still out. I mean, is it a stomach bug? Is it, what is it?
He didn't specify. The paralegal just said he barely notified me this morning. I didn't.
All right, okay, just have a seat. We're gonna find out, so I'll know what date to reset you for, okay? That way you won't have to come back.
Okay.
Jose Gallegos? Yes, that is always nice to see you. Top of the morning to you.
see you.
You too?
Mr. Gales has 2 cases. One is a June offense date for which I received an offer. Sometime in November, I think late November, we picked up another less than a gram case.
Mhm.
Part of the offer would just be the TIC that. However, we don't have the lab yet. And today's the first chance I've had to explain to Mr. Gales what the offer that was made last month.
Okay.
Is. Right, if I could just get 30 days, I think we'll come back.
Okay. All right, so the new case is a possession less than a gram case?
Yes, Judge.
All right,
And the plea would be on a third degree.
okay. Ms. Ferguson, well, today is listed as today is his plea deadline date, Bo.
I think it's because that was the old case, and then she had this new case, so I'm asking. to extend that.
Okay, I'll extend it, but I have it written in this 2023 file, but I'll extend it.
Okay, thank you, Judge.
Sure. Ms. Ferguson, can I have a 30-day reset on Mr. Gallegos?
So today was his.
Okay.
All right, we'll be back on April 6th. And the indictment I have is the 2023 CR 0058.
Yes, Judge.
And that should be the 1 to 4 grams.
All right, so that's what
Thank you.
so
Judge.
I'll extend your plea deadline date to April 6th.
April 6th. I'm walking down to 11 and tell them. Thank you, Judge. Excuse
All
me.
right, just after he signs the reset form.
Yeah, okay.
Lacey Rivett. Where's the attorney for Lacey Rivett? Court is calling 2022 CR 11926, State of Texas versus Lacey Nicole Rivett. Can I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense?
Jim Oltersdorf for Lacey Rivett.
And are you Miss Rivett?
Yes, ma'am.
Am I pronouncing your last name correctly?
Yes, ma'am.
Counsel, you received all the discovery and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Rivett, I'm showing you what's entitled application for deferred adjudication or community supervision. Thank you. Thank you, Jason. Did you review that document with your attorney? Did you understand it? Did you sign it?
Yes, ma'am.
Next, I'm showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Judge.
All right, Ms. Rivett, I'm showing you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with the offense of possession of a controlled substance penalty group 1 gram to 4 grams as a third-degree felony? The range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargaining agreement with the state, the court does not have to follow your plea bargaining agreement. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargaining agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand that the court would grant your application for deferred adjudication? If for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison and up to $10,000 fine.
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
She does, Your Honor.
Do you believe she's currently competent but was legally sane at the time of the offense?
Yes to both questions.
Ms. Rivett, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived a right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, fine is set at $500. The state recommends deferred adjudication. There's restitution of $114 to the Bexar County Crime Lab for drug testing. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State.
Yes, Your Honor.
Showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? And did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement. State is requesting that your deferred adjudication be for a term of 3 years. There be a TAP evaluation, 150 hours community service restitution, and no contact with Johnny Talamontes. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged in the indictment, how do you plead? Guilty, not guilty, or no contest?
Contest.
State any evidence.
Your Honor, state attached, state, most of it states as a one and all attachments.
No objections, Your Honor.
Ms. Rivett, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. State, you're excused.
Thank you, Judge.
You're welcome. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
We would waive a PSI and ask the court to proceed with sentencing, Your Honor.
All right, anything you wish to say on behalf of your client?
Judge, I just found her to be a type of person who seems to pay very, very close attention to the court, to myself. I think she will be an excellent probationer. She's been, like I said, she's been here on time. The 2 times I've met her, I've talked to her on the phone. She's just a very good individual.
All right, Ms. Rivett, do you have any children?
Yes, ma'am.
How old are they?
I have a 2-year-old, a 4-year-old, and a 7-year-old.
All right, and where are they?
They're with me. They stay with me and my mother-in-law.
All right.
Judge, her mother is present. Is that your mother or your mother?
No, my mother-in-law.
Okay,
Where's your mother?
My mother is here in the stand or in
in the courtroom.
the courtroom.
All right, so she said her mother-in-law was here.
Oh,
No,
I'm
my mother-in-law is where me and my kids live with her.
All right, but your mother is here.
Yes, ma'am.
All right, when you're drug tested today, what are the results going to be? Because you are going to get drug tested today.
Completely negative.
All right, so we'll do sentencing, but I'll do sentencing after she comes back with her drug test.
Okay.
All right, so if I can get a drug test on her. Thank you.
Do I return in an hour, Your Honor, or what?
Oh, no, it's going to be fairly quick.
Oh, okay.
Do you need any water? Okay.
Judge, I also would ask the court to allow Ms. Rivett, who lives in Wilson County.
I live in Scottsdale.
Oh, we'll handle
Okay,
that after
thank you.
she gives me the drug test.
Okay.
Nicholas Ornelas, you can come forward, please. All right, so your attorney has contacted the court, and thank you for dressing appropriately for court. I appreciate that. All right, Ms. Ferguson, on Ornelas, if I can have this set at the beginning of April, please. All right, we're going to come back on April 6th for your case. And if your attorney, if you get in touch with your attorney and your attorney wants it set sooner, we'll set it sooner.
Okay.
So your current conditions of probation, you'll still need to report. You understand?
Yes, ma'am.
All right, Ms. Ferguson, we'll give you a reset form.
Sounds good. Thank you.
You're welcome.
Oh.
All right, if I could see the parties back on Rolack, please. Okay, yeah. Is the attorney here for, thank you, counsel. All right, so we're back on the record in 2022 CR 9351, State of Texas versus Kayla Rolack. And you're still under oath. And could you restate your name, please?
Yes, yes, Cisneros.
All right, and standing in for the state.
Ruben Herrera for the state, Your Honor.
All right, counsel, you may proceed.
You stated your name. What is your profession, occupation?
Yes, I'm a family-based safety services worker for Child Protective Services.
And have you supervised or participated with Ms. Kayla?
Yes, sir. I have been her worker since September of 2022, and her case just recently closed here in February.
Okay, and can you tell the court how you have interacted with Ms. Kayla and how has she progressed?
Sure. So, part of my job is to obviously, go into the home, make sure, things are going well with her and her daughter, also to comply with services. So specifically, we had enrolled Kayla Rolack into parenting, domestic violence, and random drug screenings. She excelled the whole time. She also got protective daycare for her child. So that's where she currently is during the day. And then she does reside with maternal grandmother and Kayla during the day. But she did really, really well. All drug screens came back negative for all substances. She was compliant in all of her services, received positive feedback from all her providers. And my time in working with Ms. Rolack, I really did not experience any negative feedback, any negative experiences or anything like that.
All right. And are you fully satisfied that she has participated well then?
Yes, definitely.
As a witness?
Mrs. Narrows, does the defendant have a support system in order to help her care for the victim in this case?
Yes.
And is she? Nothing further. Witness Narrows.
All right. So how long did you supervise her?
Oh, since September of 2022.
And how
Until-
often were you seeing her?
I was seeing her about twice a month.
All right. And when's the last time she had a drug test?
February of this year.
Okay. All right. Thank you.
Thank you.
Your Honor, if I may, Ms. Kayla would like the court.
State, have you reviewed the documentations he wants to present to the court?
Of no objection to the presumption of state doctor, the defense documents.
April?
Yes. Thank you, counsel. And for the record, the court is reviewing certificates that have been offered on behalf of Ms. Rolack by her attorney. Your counsel. Thank you. Any other witnesses?
No witnesses, Your Honor.
All right, state, you're opposed to the application?
We are, Your Honor.
All right, you can make your argument, state.
Your Honor, although it's been presented that the defendant seems to be taking some steps in
All right, you all need to whisper in the box.
some substance taking responsibility for this matter. Based on the allegations, Your Honor, it shows a gross negligence and the lack of proper judgment. In fact, that the defendant did admit to leaving her child purposefully at the home without checking to see if there was anybody there to supervise the child, Your Honor. This resulted in the victim child being able to escape the residence on her own, being outside in cold temperatures with nothing but a diaper on. Based on the allegations, Your Honor, the state would oppose the defendant's application.
All right, is there a reason for the tears? Because what he's just saying is true.
No.
Now, I know people want to cry before the court because they want the court to be lenient, but let me just tell you, tears don't sway the court. I'm just here to listen to facts to see if you've done anything that would justify the court placing you on probation, okay? All right, so that's why you're asking for her to go to prison?
Yes, Your Honor.
All right. And have you state, have you had a chance to review her certificates?
I did, Your Honor.
All right, defense?
Yes, and Your Honor, we're asking that the court consider supervision for her. This offense, first of all, the child just wandered away from, in contrast to what counsel says that the child escaped. So it wasn't a matter of escaping. She was just wandered off as children off too. My client had stated, she told the police that she thought that the adults were inside the home and that the child was being taken care of. And it was just a mistake on her part. And I would like for Ms. Rolack to address the court on this issue of abandoning the child.
All right, can you raise your right hand? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
Kayla Rolack.
All right, defense.
And why do you, first of all, was this an honest mistake on your part in leaving the child?
Yes, I would never want to leave my child on purpose. I take care of her every day. I'm the only person that she's been with every day of her life. I love her and I didn't mean to put her in any harm's way.
All right, somebody want to explain to me, the crux of this entire situation is some kind of way, a 2-year-old in a diaper ended up wandering the streets in a diaper only in November, and it was cold. So, I mean, that's what we need to get to the point of, because in the PSI report, she's blaming the people who CPS has put in charge of helping her supervise the child. That's who she's blaming for her child being out and about, because in the PSI report, it states that guilt was minimized. And in the PSI report, she's stating she thought these other people who CPS put in charge of her child as the person to chaperone or supervise, she's blaming them, saying that they were supposed to be there. So somebody explain to me how a 2-year-old gets out of a apartment or residence that's supposedly locked or should have been locked.
So she was naked, not wearing any clothes, because that's how we sleep. She still goes and runs around naked. We just got out of diapers, so she usually just wears a underwear. But that's why she was naked, not having any clothes. And I do not blame anyone else. This is my fault. I should have been the one to check if anyone was there. I was just saying that I had thought, because when I laid down my daughter, my mom and my uncle were still there. So that's the reason why I didn't check, but this is my fault. I am taking full responsibility.
Okay, I hope everybody understands. I'm always curious. I have questions. It sounds odd to me, unless people are living in a mansion and you have the west wing and the east wing and people leave and people don't know it. So I'm just finding it, or I just have questions. How a child gets left, and I don't even understand how children get left in the car by themselves, but in a home, how does a child get left in a home by themselves if a parent is leaving and other people are there and other people see you leave? Nobody thinks, oh, we can't leave because there's a 2-year-old here. How does that work?
So when I laid down my daughter, my mom, we all, like, my mom and I both went into our rooms. That's why I thought that she was there. So I didn't hear no door open or close, and I hadn't come out of. So I didn't see anybody. I figured my mom was still home because I didn't see anybody out there.
So you don't see anybody and you just leave your daughter in a house and you haven't seen anyone?
Just because I thought that my mom was in her room still.
Defense, you may continue.
I have no further questions, Your Honor.
Any questions?
Just briefly, Ms. Rolack, how far away is your mother's room from your room?
It was like, down low.
Did you knock at all to check if she was still there?
I don't think so.
Did you walk around the apartment to confirm that there was any adults present before you left the apartment?
I just walked through the living room.
Nothing further else.
All right. Any other witness defense?
No, Your Honor.
All right, I want a UA today, then I'll make my decision. All right. So, Ms. Abrams, if I could have a UA on Ms. Rolack, please. Yes.
First touch.
Miss Rivett's going to put negatives.
That is so awesome. It's starting out to, I'm excited about that. Ms. Rivett. If you come forward. Who's the attorney for Ms. Rivett?
I think it's Jim Olson, Judge.
All right. As soon as your attorney comes back, we'll take up your case. All right, Raul, Lucio. If you come forward. Hello. Hi, let me see your attorney. All right, Mr. Lucio, thank you so much for dressing appropriately for court. Your attorney is out ill. So we're going to bring you back on April 6th. If your attorney wants you brought back sooner than then, we'll bring you back sooner than, okay? All right, do you have any questions about anything?
No, ma'am.
All right, Ms. Ferguson, on Mr. Raul Lucio, if you can give him a reset date for April 6th. You're welcome. All right, after you receive your reset form, you're excused. Who's here on Derrick Reyes? All right, we'll take up the plea and then we'll take up the other issue.
Oh, there's no plea, Judge. It was just a motion to modify. Reyes.
All right. Oh, you know what? I pulled Tracy Bobby's file because it was stuck with the others. All right. All right, the court is calling NYMAG number 646223, State of Texas versus Derrick Reyes, Derek-Reys. Can I have parties announced for the record for the state?
Jason Garrett, Your Honor.
Defense?
Will Brooks, and I represent Mr. Reyes in conjunction with Mr. Luis Martinez, who's downstairs in the 399 judge.
All right, any objection to proceeding without Mr. Lewis?
Not from the state.
Not from me, Judge.
All right, and the court is also calling NYMAG number 646224. All right, the defense has filed a motion to amend conditions of bail. They're asking for removal of GPS. Did you have a chance to review the defense's motion?
I spoke with defense counsel, Mr. Brooks, about that, and the state is opposed.
All right. All right, defense, do you have any witnesses or is this just argument?
It's just argument, Judge.
All right, defense, you may proceed.
Judge, I certainly understand Mr. Garahan's position on our request. I understand it's a big request in light of the allegations, Judge.
And what are the charges? Because I don't see it listed in the motion. And 223, what is the charge?
It's intox manslaughter, Judge. As is 224, Judge.
Okay.
Same offense state, Your Honor.
All right, thank you. So I'll hear argument.
Judge, in this instance, I understand that we have a big ask, asking the court to consider removing the GPS device. Historically, Mr. Reyes has been supervised by pretrial services for about 1 year and 3 months. His officer Barda, sent him, had an email exchange with him where I guess she was moving on to other supervision or other part of pretrial services, but she did point out to him that he had been an exemplary personal pretrial services. He had had no issues and suggested that he speak with his attorneys about asking for the device to be removed. He has not had any issues with that device, Judge. He is on full house arrest.
All right, and state, have you received the email from Ms. Barta?
I have not, I was told about it.
All right, and it was attached to defense's motion.
That's right, Your Honor.
And Judge, in that respect, he's demonstrated he's capable of complying with pretrial services. The issue, Your Honor, is he was employed, but lost his job. He was working from home. After losing that job, he's found it very difficult to gain other employment while working from home. Court's not inclined to remove the device. A better ask might be for the court to consider granting him partial or GPS so that he's able to search for and find a job, Your Honor. But that's the thrust of the motion and that's our request today.
Okay, so I'm assuming he's not driving.
Correct, Judge. We submitted affidavits of non-driving almost immediately.
Okay, and then the issue, then it appears that there's a financial issue.
Yes, Judge.
All right, so state, do you have any objection to partial GPS to allow Mr. Reyes a window of time to search for employment? And then once he obtains employment, that he'd be allowed to work with GPS?
We're not opposed to that.
All right. So what I will do, Mr. Reyes, in each case, I will give you a time window so you can search for employment. There's to be no driving. So what hours to search for employment are you asking for, counsel?
Judge, any window the court would consider during daytime hours, I guess, something between 9 and 5. Judge.
All right. So I'll give him 7 a.m. To 5 p.m. because it doesn't start getting dark until I think probably like 7:30 here, which means they're getting ready to change the time. Thank you, daylight savings, which is not needed, but okay. So we'll search for employment from 7 a.m. to 5 p.m. State, are you okay with that?
Yes, Your Honor.
And then we'll do partial GPS for employment. And the search for employment 7 a.m. to 5 a.m. will be Monday through Friday. If there's some sort of employment that involves you being interviewed or something happening on Saturday or Sunday, just inform GPS.
Yes.
And then I'll ask that the fees are deferred until employment obtained. Now, it's a third-party contract, so I put that order in there, but whether they follow it or not. And I can also ask for the free GPS device that appears to be floating down somewhere, but nobody's ever able to actually touch it.
Okay.
All right, and counsel, anything else?
Judge, I'd point out to the court his current monitoring situation since he was on full house arrest. I don't know that there's any alcohol monitoring outside of testing. You go test. I didn't know if, since he was going to be out of the household searching for jobs, if the court wanted that to remain the same. In other words, I wanted to be honest with the court on that point.
No, I appreciate that. So what we'll do is we'll do weekly UAs. So when he goes out, then he can do the UA. And then counsel, if you want to speak with pretrial services, I know there is a device that is an alcohol monitor device. And it's alcohol monitor, also GPS. If you want to look into that, that may be cheaper than the GPS.
Okay, I will do that, Judge.
All right, thank you so much.
Thank you. Thank you, Your Honor.
You're welcome.
May we be excused, Judge?
Yes. And if you want a copy of the court's order, I'll fill it out in just a moment.
Okay, thank you, Your Honor.
Thanks.
Hero, if you could switch with this young man.
All right, Mr. Oldestorff, we're ready on your client, Lacey Rivett. All right, we're back on the record in 2022 CR 11926. Ms. Rivett, they're telling me you were negative. I am very proud of you. Thank you. So how have you been able to remain clean and sober?
I actually went to rehab from November 15th to January 3rd. I moved out of the city after that. I went to Stockdale where my kids are, got a full-time job. I've just been working and staying home.
All right, and what do you do for employment?
I work at Holmes Food in INC. It's a chicken production factory.
Ah, okay. Do the chickens come in alive and
They
leave
do.
out?
They do. They come in alive. and
Do they
leave
know
out.
what's about to happen to them?
I asked the same thing when I first started, actually. That's funny.
Are you able to look them in the eye and know that
No.
you're sending them on?
Well, I just see them come in on the trucks and they kill them outside and stuff. By the time they get to me, I'm in packaging. So they're already,
Oh, the feathers have.
yeah,
been looking at-
they're already ready to be packaged.
I
and sent
raised
off.
chickens in 4-H are giving me memories of
I
chickens that
know.
would remember me and so on.
It's like the movie Chicken Run, you know? All right. And so who's staying with you?
My kids and my mother-in-law. I'm actually soon to be back in my own house in Stockdale.
All right. And so where are you residing? Stockton?
Stockdale.
Stockdale.
Yes, ma'am.
And where is that in Texas?
So there's Nixon, Stockdale, Floresville's kind of over here, Lavernia.
Okay, all I recognize is
just for-
Floresville and
just-
Lavernia.
In the direction of Seguin, a little further, but a little further south.
23,
All right, which county is that?
Wilson County.
So how are you maintaining your sobriety? Is it just getting away from people? Are you taking classes?
I do NA meetings online. If I'm gonna be honest, I should probably be more active in like the recovery part of it, but being away from everyone, and just being with my kids.
Okay, I'm gonna require AA meetings
Okay.
because to me, you gotta stay vigilant.
Okay.
And sometimes people get placed on deferred, they're excited because they thought they were going to prison. And then they go celebrate or
Yeah.
they stop being vigilant. And you have young children.
Yes, sir.
So you want them to admire you and look up to you.
Yeah.
So you gotta stay on the stay on the straight and narrow, okay?
Yes, sir.
All right, this is what the court is gonna do. There's a $500 fine that will be probated. 3 years deferred adjudication. 150 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination with booster. The court is not requiring you to get that, but if you do, 40 of those hours will be waived.
What type of vaccination?
COVID
Oh,
vaccination.
okay. Interesting.
Parenting classes.
Okay.
Uh, Yes,
I did complete parenting and I have a certificate for it. Just
you'll have to
recent.
provide it to probation.
Okay.
All right, and the remaining community service hours will be waived once she completes parenting classes.
Okay.
There's to be no contact with Johnny Palamontes.
That's fine.
We'll do a transfer to Wilson County.
Okay.
I'm gonna want 90 meetings in 90 days.
That's fine.
There should be regular reporting by Zoom or in person. Regular UAs. Proof of employment within 15 days.
That's fine.
No employment as a home health care provider or with minors.
Okay.
So when you're living with your mother-in-law, is it just you, your mother-in-law and your children?
Mhm.
Okay. Defendant is not to reside with any adult males. And if they're able to do, are they able to do field visits in Wilson or no?
Your Honor, I'll have to check to see if they could do field visits in Wilson County.
I'll just do
with
it.
the Wilson County probation.
All right, I'll put if possible. Well, no, I'm just gonna say field visits. One time per month. And is there anything else she needs?
No, Your Honor, I was going to point out to the court that probation is now within the state of Texas. We can give probationers a virtual office visit officer.
Yes.
So, but that wouldn't take care of like the field visits if so.
Well, let's make sure the virtual is done here, but if they do actually do field visits in Wilson Council, we can transfer it.
Okay.
All right, is there anything else you need from the court in order to be successful?
No, ma'am. Just because you do require the NA meeting or AA, will y'all help me find some in Wilson County? Because
Oh, if you Google, there are,
Wilson, I tried to find some in Wilson County and they're super hard. I don't know of any off actually right now. And driving to San Antonio every day for 90 days is a lot.
all right, there is a number you can call.
Okay.
It's 866. 641-9190. And that will give you a list of all the AA meetings.
Okay. Do you mind if it's NA?
Oh, it can be NA
Okay,
or
okay.
AA.
Just making sure.
Yes. And just one moment. All right, is there anything else from either side?
No, Your Honor.
Anything else you need from the court to be successful? Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
All right, good luck to you.
Thank you.
You're welcome.
Thank you.
Oh, and Caroline, those motions on the bond that goes with that. This is done. All right, could I see the parties on Rolack? All right, we're back on the record in 2022 CR 9351, State of Texas versus Kayla Rolack. Court is here. Counsel. Thank you. All right, we're back on the record in 2022 CR 9351 Kayla Rolack. And the court asked the defendant to do a UA. And I'm very happy to say that the UA was negative. All right, is there anything else from either side with regards to argument?
Nothing from the state, Your Honor.
Anything else from the defense?
Well, no, I have a request, but
What is your request?
she's been on the monitor for 5 months. We're asking if it can be removed.
Oh, she's going to remain on the monitor. All right. So, Ms. Rolack, I wanted to tell you, and this is why I always keep an open mind on everything. Just reading your history and looking at everything, someone would suggest that you should go to prison. But, you know, I always tell people whether you think a judge is going to do something or not, and I would always tell my clients, hey, you know what? We have to give the judge something to suggest you're not going to prison. So don't come in and throw yourself on the mercy of the court and you have done nothing. You understand? So I see that you've done a lot. I see that you completed everything with Child Protective Services. And sometimes Child Protective Services, they're always overworked and underpaid, but you actually had a good caseworker to stay on top of you and make sure that you were doing everything that you were supposed to be doing. And I see that you, during this time, you got your GED, you're enrolled in college, that's great. And to all the children who are out there who always think that the best college to go to is someplace that's not at home, sometimes, you know, the best college is a college that's actually in your city. People always want to go to some other college because they think it's the best college. And I always say the best college is wherever you are if you make it that best college. So I see that you've done that. You have supervision because you're not living by yourself. I'm going to want you to continue to not live by yourself. Now, once you've been on probation for a while, your attorney can always come back and ask the court to reconsider that part. So who are the persons you're living with?
I live with my mom
Okay.
and my daughter,
And what's your mom's name?
Brenda Marshall.
I'm sorry?
Brenda Marshall.
Brenda Marshall. And I'm assuming your mom wants you to remain with her.
Yeah.
All right, so this is what the court is going to do. The court is going to grant your application. And I'm actually going to give you deferred adjudication. So 4 years deferred adjudication. There's to be a $1,500 fine that will be probated. take in consideration County Court Cause number 688-620, 691-438, Night Mag number 675-530. Proof of employment within 30 days. And in this court, if you're on probation here, I don't allow you to be a home health care provider. So there's to be no employment as a home health care provider with minors. 250 hours community service restitution. Those hours will be waived if you provide proof of enrollment in college, which you have. You need to provide that proof to probation today. And for the court to give you credit for that, you need to take at least 9 hours a semester. And I don't allow people to do that thing where they say, oh, here's my 9 hours for semester, and then they drop classes. That's expensive.
Can I say something?
Yes.
I actually am going for a pre-major in psychology, and then I want to go to UTSA. So after these, I'm gonna do like, I think around 17 hours a semester because I'm.
Thank you. See, when I tell people that every semester I would do like 24 hours a semester, people don't believe it, but it can be done.
Yeah.
All right, so provide proof of enrollment in college with at least 9 hours. Probation, I'm going to ask for parenting classes. She's already completed those, so you'll need to provide documentation to that. She is to reside with Brenda Marshall. And so it's only you two in the household, right? All right. There to be no adult males in the household residing there.
Okay.
If something changes, you can let me know. I just found from my experience as a defense attorney on CPS side, what ends up happening is mothers are doing great. And I've had male clients over there too. They're doing great. Then the next thing you know, they end up getting a new partner. They don't vet that partner appropriate, and everything that goes downhill. So that's why I'm putting no adult males. So she's not allowed to reside with any adult males. Probation, I'm going to want field visits once per month. Regular reporting, and the field visit can count as her reporting, and that field visit is until further notice. And we'll do regular UAs. Probation, is there anything else she needs?
No, Your Honor.
Is there anything else you need from the court to be successful?
If, I know you said I could take my certificate that I already did parenting class.
Yes.
Can I still take another one? Because this last one that I took with the San Antonio Fatherhood Campaign, I actually learned a lot. And if I could just keep learning, because my daughter is getting older.
Okay.
And also, is there any way that I can get, that y'all can help me with like therapy or like getting into counseling?
All right. So what I'll do is probation, we'll add parenting classes. And make sure you notate in there the parenting classes were at Ms. Rolack's request. And also, do we need a mental health caseload or mental health evaluation probation?
We'll do a mental health evaluation for referral.
All right, we'll do a mental health evaluation for referral.
I did do that, and she said that I didn't have any like things, but I have a lot of anxiety and I just deal with a lot of stress and stuff. So that's why I asked for like the therapy or counseling.
All right, they'll take care of it. They're gonna make it happen. If it doesn't happen, let me know.
Okay.
I'm here. All right, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it, and did you sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. All right. All right, good luck to you. Good job.
Thank you so much. Thank you so much.
Oh, you're welcome.
Your Honor,
Yes.
did you Did you specify?
Wait, am I still on house arrest?
Oh, with regards to the monitor probation,
Yes, Your Honor.
let's keep her on the monitor for 2 months. If there are no issues, then it can be removed.
GPS parking.
Yes,
Like, can they take my daughter to the park and stuff?
yes, it's probation. Just make it tracking,
All right.
Thank
but
you
you'll
so
still
much.
need to let probation know where you're going to be, okay?
Okay, thank you so much.
You're welcome. And this is, the top copy is for the state. All right, thank you.
Have a great
Just,
week.
oh, thank you. Just remain in the, she needs to remain in the courtroom so probation can go over conditions with her. And Caroline, I think my docket has disappeared in somebody's file. My docket, so it may be in, what's her name? Rivette's file. All right, who's here on Tracy Bobby or Bobby Tracy? Court is calling 2023 CR 0063, State of Texas versus Bobby Tracy. Could I have parties announced for the record for the state,
Daniel Escobar from the state of Texas.
for the defense?
Mr. Brown, Matthew Brown from Mr. Tracy.
Thank you. And are you Bobby Tracy?
Yes, I am, Your Honor.
Thanks for speaking up. I appreciate that. Other people whisper. All right, counsel, I'm showing you discovery acknowledgement. Have you received all the discovery in this case and did you review it with your client?
I have, Your Honor, yes.
Court will find that the state is in compliance with discovery. Mr. Tracy, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor, I did.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Judge.
Mr. Tracy, I'm showing you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it and did you sign it in all the appropriate places?
Yes, I did, Your Honor.
Did you understand you're charged with felony and possession of a firearm as a third-degree felony? The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Tracy, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, Your Honor. I did.
According to the plea, punishment is to be assessed at 2 years in the prison and there are no applications. Did you understand that to be the plea?
Yes, Your Honor.
Defense,
Yes, Your Honor.
state,
Yes, Your Honor.
showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it and did you sign it?
Yes, Your Honor. I did.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no
No
contest?
contest, Your Honor.
State, any evidence?
Your Honor, state all for states except one in all attachments.
No objection.
All right, state, you may be excused.
Thank you, Judge.
Mr. Tracy, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, I did, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports But most importantly, there will be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
We asked to follow the agreement. This Mr. Tracy inherited property from a family member and the weapon came with property and he knew better, but he just left it in home.
All right, and the case that he's on parole for is the 2018 CR 8401?
Correct.
All right, the court will follow your agreement. Court will sentence you to 2 years in the prison. Give you credit for any time served, and this will run concurrent with 2018 CR 8401. Mr. Tracy, since you're on parole, if the parole allegations haven't been heard, the court can't necessarily force parole to run this case concurrent with your parole. So it will be up to the parole board whether or not it's run concurrently, but I'm requesting that it run concurrent.
I understand.
Okay,
Thank you.
you're welcome. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am, I do.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. And also because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. You understand?
Yes, I do.
All right, good luck to you.
Thank you, Your Honor.
All right, thank you.
Thank you, Your Honor.
Who's here on Rolando Garza? Hi. Hi, it's always great seeing you. Where is your client? All right, if you come down, please. Let me just find your client on the docket.
Yeah. Page 19.
All right, thank you. All right, what's happening with this case?
Your Honor, I believe previously he was representing himself with standby counsel. He has since hired me to represent him, not as standby, but as lead counsel. So we are reviewing discovery, and there's also I received a plea with an unindicted third count that I need to look into.
What new discovery?
Sorry?
What new discovery?
No, I'm reviewing discovery. I didn't say new.
Oh, okay.
Apologies.
All right, so this kidnapping, is this family violence?
Yes, kidnapping,
Yes, Your
family
Honor.
violence.
All right, and what are the new cases? The new case is just a drug case, is that correct?
No, there's an unindicted third, which is the endangering of a child. But it's unindicted. It's just a part of a plea offer.
All right, so I have the theft case.
They were
kidnapping
together.
case. Those are the two that's indicted, and there's not another indicted case?
No. Apologies.
All right. Apologies. All right, so Mr. Garza, how old are you?
40 years old now, Your Honor.
40?
Yes, ma'am.
All right, and so an offer has been tendered?
It has, Your Honor.
All right, this is an old case. We're gonna bring you back on Thursday, and you need to let the court know whether or not you're accepting the offer. You understand?
Yes, Your Honor.
And that will be your plea deadline date. After that date, the court will not accept any plea bargain agreements in this case. Do you understand?
Yes, Your Honor.
All right, so we're going to be back on March 9th.
Thank you, Your Honor.
Ms. Ferguson, if you can have Mr. Rolando Garza back on March 9th for a plea deadline date. All right, thank you.
Thank you.
Okay. Yes. Move for some. Okay. Okay, just give me a moment. Which case is this again? Okay, let me look and see. And where is Christopher Barode?
He's in the, he was in the first one. He's in the first one, Your Honor. He's in the black. Hoodie.
Why is he always sleeping in court? Deputy Lord, let him sit in the jury box until he is wide awake. All right, you can sit in the jury box. We'll help you wake up. Travis Molden.
We're here.
Molden.
And Daniel, I'll check on that in just a moment.
I haven't seen her in a second long.
And probation, this is no application. All right, court is calling 2018 CR 9310. Thank you, Jason. You're doing it all today. State of Texas versus Travis Molden. Could I have parties announced for the record for the state?
Jason Garahan, Your Honor.
Defense?
Charles Bunk.
And are you Mr. Molden?
Yes, ma'am.
Thank you for speaking up. Mr. Bonk, have you received all the discovery in this case and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Molden, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, we are, Your Honor.
All right, Mr. Molden, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with harassment of a public servant? Normally, that's a third-degree felony. The range of punishment would be anywhere from 2 to 10 years in prison and up to a $10,000 fine. It's a court's understanding that the state is proceeding on the repeat offender enhancement allegation. It's that if that is proven to the court, then your range of punishment will be anywhere from 2 to 20 years in prison with a possible fine up to $10,000. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Molden, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, you'd agree that you've been previously convicted of a felony for enhancement. Punishment is to be assessed at 2 years in the prison. There are no applications. The state will take in consideration 2018 CR 10374. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Judge.
State?
It is, Your Honor.
Showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that paragraph with your attorney?
Yes,
Did you
ma'am.
understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Judge.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
Yes, Your Honor. State offer state exhibit number 1 with all the statutes.
No objections.
Mr. Molden, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
All right, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. With regards to the enhancement allegation, how do you plead? True or not true?
True.
All right, state, you may be excused to confer.
There was 2 other additional things. One of that was last minute. They could also be just projected.
You're welcome.
There's two places that they're projecting, so if nothing else pending.
All right, could we go off the record for a moment, please? And all right, we're back on the record in 2018 CR 9310 with regards to the repeat offender enhancement allegation state.
Your Honor, in lieu of we're missing a
Excuse me, if you all are sitting behind the court reporter, need to move it to the end. Thank you. All right, state, are you waiving the repeat offender enhancement allegation?
Yes, Your Honor.
Any objections?
None.
All right.
So that's kind of initial right there.
Yes. So, Mr. Molden, you understand then with the waiver of the repeat enhancement allegation, then your range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine?
So yes, ma'am.
Yes, ma'am.
Right. And knowing that change has been made, do you still wish to continue with this plea bargain agreement?
Yes, ma'am.
All right, thank you. Oh, no problem. It happens. It's a Monday.
It is.
If everything went well, it wouldn't be a Monday. All right, the court then will review states exhibits 1 and attachments for sufficiency. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
We believe he's deserving of the plea bargain. We have to follow it, and at the appropriate time, I have some
All right,
custody
I'm sorry,
dates.
just 1 second. Everyone, the court is on the record. If you cannot whisper, then that means you should not be talking. And if I can hear you out there, when you come before me, make sure you speak up so I can hear you. All right, defense.
I have, at the appropriate time, I have some custody dates to read into the record when the court's ready.
All right, the court will follow your agreement, sentence you to 2 years in the prison, give you credit for any time served, take in consideration 2018 CR 10374.
Okay, Judge, for the record, he was in federal custody from July the 26th of 2018.
Just 1 second. Excuse me. Hi. She needs to make sure she hears his custody. So if y'all will wait.
That's right.
All right, so he was in federal custody. What are the dates?
July 26th of 2018 through April 29th of 2022. And he was in the county jail, April 29th, 2022 through May the 1st of 2022. Back in federal custody, June the 23rd of 2022 until February the 10th of 2023. And he's been here in the county jail from February 10th of this year until today. So I know the court can't satisfy the judgment, but he has the time to make the judgment satisfied once the paperwork is reviewed at the jail.
All right, and Caroline, I've written on the docket sheet.
She has the dates also. I've given
awesome.
them to her prior to the sentence, prior to the court.
All right, the court will give you credit for the time that you were in federal custody while this case was open. And the court will note for the record that the dates defense counsel has given to the court is July 26, 2018 through April 29, 2022 in federal custody. Then the Bexar County Jail from April 29, 2022 to May 1st, 2022. Then federal custody for June 22nd, 2022 to February 10th, 2023. And then the Bexar County Jail from February 10th, 2023 to the present.
That's correct.
Next, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. How old are you?
33, ma'am.
All right, so you're gonna have to start making better life decisions. Otherwise, you're gonna end up in prison or the Bexar County Jail for the rest of your life, or somebody's jail. You understand?
Yes, ma'am.
Do you have children? I'm sorry?
One,
All right, and how old is your child?
4.
I'm sure your child would like to see you, okay? All right, good luck to you. Thank you, Mr.
Thank you,
Vaughn.
Judge. And he had some property that was taken at the time. I'll be coming to court tomorrow with a motion to release some property.
All right,
All right,
thank you. All right, Christopher, Burrows, come forward.
Sorry,
All right, I mean, and you're late.
my paperwork say 11 a.m.
Okay,
I have it.
Okay. Here's the thing, there's to be no sleeping in court. Do you understand?
I'm sorry, but I came all the way from Austin, Texas. That's why I'm there.
Well, Austin, Texas is not that far. I've driven through Austin. Now, mind you, traffic it is always horrible in Austin, no matter when you go.
I apologize.
But no sleeping in court. You understand?
Yes, yes, ma'am.
All right, Ms. Ferguson. On this one, defense counsel is ill and they want a contested hearing. When can we have contested? And state you may release your witnesses.
Yes, ma'am.
We can do March 30th.
All right, we're gonna come back on March 30th. And what time is Ferguson?
We can do it at 10 o'clock.
All right, that'll be at 10 a.m. Ms. Ferguson will give you a reset form.
Thank you, Judge.
You're welcome. Thank you.
Just have a single point.
Who's here on Jason Lopez? Jason Lopez.
Yes, Your Honor, we're back.
Okay, no problem. Who's here on Antonio Ruiz? All right, if you'll come forward. Probation, this is no application.
Thank you, Your Honor.
All right, the court is calling 2023 CR 1201, State of Texas versus Antonio Ruiz. Could I have parties announced for the record for the state?
Jason Garahan, Your Honor.
Defense.
Raimundo Alemán for Mr. Ruiz.
And are you Mr. Ruiz?
Yes, Your Honor.
All right, just one moment. All right, counsel, have you received all the discovery in this case and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Ruiz, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
Both counts?
Yes, Your Honor.
Mr. Ruiz, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand in count one, you're charged with the offense of possession of a controlled substance, penalty group 1, 4 grams to 200 grams? And that's the possession of cocaine. The range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. Did you understand?
Yes, Your Honor.
Did you understand in count two, you're charged with the offense of possession of a controlled substance, penalty group 1, 4 grams to 200 grams? And that's methamphetamine. The range of punishment for that is anywhere from 2 to 20 years in prison and up to $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Sorry.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, sir.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, sir.
And did you intend to give up those rights and enter into a plea in this case?
Yes, sir.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor, at all times.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Ruiz, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea bargain agreement?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain agreement, that you review that document with your attorney. Did you understand it?
Yes, sir.
According to the plea bargain agreement, the state is proceeding on count 1 and count 2. They're asking that your punishment be assessed at 2 years in the prison, and there are no applications. Did you understand that to be the plea?
Yes, sir.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
Yes, it is, Your Honor.
Next, I'm showing you the paragraph entitled waiver repeal paragraph. Did you review that paragraph with your attorney? Did you understand it? And did you sign it in both places?
Yes, sir.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, sir.
Counsel, are there been any such motions?
No, Your Honor.
Then to count one of the indictment, how do you plead? Guilty, not guilty, or no contest? Count two, how do you plead? Guilty, not guilty, or no contest?
Contest.
State any evidence to support the defendant's plea?
Yes, Your Honor. State exhibit number 1 with all its attachments.
Any
No.
objections?
No objection. Your Honor.
Mr. Ruiz, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, sir.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call them the right to remain silent?
Yes, sir.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there would be no live testimony. Did you understand?
Yes, sir.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. Court will find you guilty of count 1 and guilty of count 2. Are you proceeding with sentencing?
Yes, Your Honor.
All right, the court will follow your agreement. The court will sentence you to 2 years in the prison and count 1 and 2 years in the prison and count 2. Count 1 and count 2 are running concurrently. Court will give you credit for any time served. Showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that with your attorney? Did you understand it?
Yes, sir.
All right, because this is plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, sir.
Because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to the attorney. Do you understand?
Yes, sir.
All right, good luck to you. We can go off the record. How old are you?
35.
You got to change your life. Otherwise, you're going to end up in and out of prison, okay?
Sure.
All right, good luck to you.
Thank you.
Epifino Marcata.
Downstairs, Your Honor.
All right, Ms. Ferguson.
He's downstairs. You don't have room.
Oh, no, that's fine.
Sorry to interrupt. We asked for Jason Lopez to be out here as a note on the board.
Okay, all right. So Epifino Marcata. Ms. Ferguson, we really need to recall this back. Defense attorney is in trial in the 399th. When is it coming back? Let's put it at 3 weeks. All right, Deputy Laura, can you let him know his attorneys and jury trial and we'll be back on March 30th?
Yes.
Tyler Small.
Here, there.
All right, where are we on this case?
Judge, I confer with the prosecutors, it should be a protective order in regards to CPS records, and then in addition to that, some jail calls they'll be providing to me. See if the court can bring us back on the 23rd for a discovery compliance, that way I can get an offer as well.
All right. Are those the only outstanding discovery? Because I have in here on January 30th, acknowledgement of discovery was signed. So now I'm being told that there's other outstanding discovery.
That was signed as the discovery that had been provided up to that point, and we spoke that day in regards to the additional discovery.
So CPS records and jail calls.
Yes, Your Honor.
State, and you're not prepared to make an offer today,
Not
correct?
at this point, Your Honor, but we'll have one ready for council by the next 48.
All right, Ms. Ferguson, can I have a 30-day reset on Mr. Small? All right, we'll be back on April 3rd.
Thank you, Judge.
Thank you.
And Judge, that was only for discovery.
That's for discovery, and the state is going to make an offer. Thank you. Who? Yes, I put that up. Mhm. Oh, you know what? Here. Let me see if I have a Lopez. So that's done. I don't have a file on it. Let me see if I have a file on Lopez. Oh, yeah. But there's no sticker. Is there a sticker attached?
No.
Yeah, I don't have a sticky attached to it. All right, thank you. Who's here on Felix Apolinar? Felix Apolinar, who's the attorney?
That's fine, Judge.
All right, so where are we on this case?
Judge, the permits came up. I'm gonna ask you about the deadline. We can make it. Be ready to make a decision by the time.
All right, Mr. Polinar, you're going to come back tomorrow. Ms. Ferguson? If you can give Mr. Felix Apolinar a return date for tomorrow?
And Judge, I have actually confirmed with him, more likely he wants to go to trial, so.
Oh, there's going to be a jury here tomorrow. Yeah. All right, so Ms. Ferguson will give you a reset for tomorrow. All right, thank you.
Or you can have a seat. Your attorney will take you your reset letter.
All right, Mr. Lopez, Jason Lopez, is he out here in the back? All right, Ms. Ferguson, let's recall this in 20 days, please. All right, Deputy Laura, can you let him know his attorney is ill? We'll be back on the March 21st.
Yeah.
Thank you. State, Mr. Lopez is coming back on the 21st.
Yes, Your Honor.
Who's here on Gerald Wilkerson? All right, if you all come forward, please. And probation, this is no application. Court is calling 2022 CR 11625, State of Texas versus Gerald Wilkerson. If I can have parties announced for the record for the state.
Jason Garrett, Your Honor.
Defense.
Renee Munoz on behalf of the defendant.
And are you Mr. Wilkerson?
Yes, ma'am.
All right, counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case and did you review it with your client?
I did, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Wilkerson, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do so waive.
State, are you proceeding on the indictment as presented?
Yes, we are.
Mr. Wilkerson, I'm showing you what's entitled Court Admonishments. Did you review that with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with the offense of theft under $2,500 enhanced as a state jail felony? Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to go to trial. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
I do.
Counsel, has your client been able to provide you with any defenses to this offense?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
In my opinion, he is.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Judge, that is correct.
Mr. Wilkerson, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
I am.
Are you a U.S. citizen?
I am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 1 year in the state jail facility. Taking in consideration 2023 CR 0219, 2023 CR 1350. County Court cause number 697702, CM number 106475. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? And did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counselor, have there been any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence?
Yes, Your Honor. State exhibit number 1 with office attachment.
No objections.
Mr. Wilkerson, I'm showing you what's entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and states you may continue to confer. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are we proceeding with sentencing?
If we may, Your Honor.
Anything you wish to say on behalf of your client?
Yes, Your Honor, my client is taking responsibility for his actions. He has, while some of these charges were pending, completed lifetime recovery, inpatient substance abuse. And after his time at state jail, intends on going back to that facility to work on his substance abuse issues, which may have led to him being charged with some of these steps, Your Honor. There was no restitution owed. Everything was recovered, Judge. And we ask the court to respectfully abide by the plea bargain agreement.
All right, Mr. Wilkerson, if you would like, I can recommend the therapeutic community for you while you're at the state jail facility. It doesn't increase the time you're at the state jail facility, but it will hopefully help you with any drug issues you have.
Yes, ma'am. That was good.
You'll still have to request it though, okay?
Yes, ma'am.
All right, the court will follow your plea, find you guilty, sentence you to 1 year in the state jail facility, give you credit for any time served, take in consideration 2023 CR 0219, 2023 CR 1350, county court cause number 697702, CM number 106475, and the therapeutic community. Anything else with regards to sentencing?
Your Honor, my client just wanted me to request of the court if he could be presumptively considered for the diligent participation credit. If he does well and advised by a therapeutic program while in state jail, and if he does well by abiding by programs and good behavior.
All right, Mr. Wilkerson, I actually receive those routinely. So just make sure that you're doing things to show the court that you're trying to rehabilitate yourself, okay?
Absolutely, yes, ma'am.
Showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that document with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
And because this is a felony conviction, sorry, Caroline, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
All right, we can go off the record. Mr. Wilkerson, you can't continue to pick up theft cases. At some point, you're going to look up and find your life has been wasted away in and out of custody and for things.
Right.
So you're going to have to get your life together. Do you have any children?
3 boys,
What are their ages?
17, 7, and 5.
All right, so the 17-year-old
He's getting ready. to
needs
graduate.
guidance, right?
Wow.
The 7 and 5 need guidance. They're looking for you. And I know you want to be someone that your children look up to. So you're going to have to make some changes, okay?
Yes, ma'am.
All right, good luck to you.
Thank you. Thank you, Your Honor.
You're welcome. Who's here on Patricia Ann Pettis? All righty, we'll come back to that one. Who's here on Ralph Delgado?
Both of those, Your Honor, are compliance hearings.
All right, just give me a moment of that.
Okay.
Who's here on Roland? I'm sorry, Ronald Rodriguez.
Hi, George.
All right, come forward. And probation?
Yes, Your Honor.
My understanding, this is for probation. And Diana, this is 2 cases. Excuse me. So y'all are in the back. No talking behind the court reporter. It's Monday and in this court, we always try to make people's job as easy as possible. All right, court is calling 2023 CR 0529 and 2023 CR 0531. State of Texas versus Roland Rodriguez. Can I have parties announced for the record for the state?
Ruben Herrera for the state.
Renee Munoz on behalf of Mr. Rodriguez.
Are you Mr. Rodriguez?
Yes, ma'am.
I'm sorry, I'm just trying to find the acknowledgement of discoveries. There we go. Counsel, in each of the cause numbers, have you received all of the discovery, and did you review that discovery with your client?
Yes, Your Honor, I have and I did.
All right, in each of the cause numbers, the court will find that the state is in compliance with discovery. Mr. Rodriguez, in each of the cause numbers, I'm showing you what's entitled application for community supervision. Did you review those with your attorney? Did you understand them? Did you sign them?
Yes, ma'am.
In each of the cause numbers, I'm showing you what's entitled true bill of indictment. Did you review those documents with your attorney? Did you understand them?
Yes, ma'am.
Counsel, do you waive the reading of the indictment in each cause number?
We do so waive, Your Honor.
Stating cause number 2023 CR 0529, are you proceeding on the indictment as presented? It appears that you are.
Yes, Your Honor. Sure. Sorry.
That's okay. And in cause number 2023 CR 0531, are you proceeding on the indictment as presented?
Your Honor, as to that case, we're proceeding on count 3, waiving the main counts.
All right. Any objection to the state's waivers?
No objection.
Mr. Rodriguez, in each of the cause numbers, I'm showing you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review those documents with your attorney? Did you understand them? Did you sign them in all the appropriate places?
Yes, ma'am.
And the cause number ending in 0529, you're charged with assault family second offense. And the cause number ending in 0531, you're charged with assault family choking strangulation. Each of those cause numbers, the range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. Did you understand?
Yes, ma'am.
And each of the cause numbers, if you have a plea bargain agreement, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for. Let me, just one second.
Yes, sir.
Have we already done the applications? Because I'm seeing on the docket sheet, I have where he's already pled no contest.
We were doing the plea last week, Your Honor, in the middle of that sexual assault trial, I know.
Yes.
And then he did plea, and then the court respectfully requested that we attend court today to finalize it.
Oh, thank you.
So I didn't know if the judge wanted to do the whole
No, because I mean, he's already entered the plea.
when we started. Okay.
Donna, they're making you take down more than you need to take down.
Sorry.
We're gonna find out who's responsible for that. I'm not gonna take the blame.
Sorry about that, Your Honor.
That's okay. All right, so you're here for sentencing. You entered a plea of no contest and cause number 2023 CR 0531 to count 3. The court found there was sufficient evidence to find you guilty. And you entered a plea of no contest in 2023 CR 0529. All right, are both parties ready for sentencing, state?
Your Honor, I think there was something on Friday about the Bexar.
Well,
That was,
should we go off the record briefly?
Sure.
I'm trying to remember why we.
Okay.
The judge wanted to know y'all's efforts to contact them during the meeting.
Okay, so we're into further out? Okay,
Do y'all need to check?
I don't think we were able to get in touch with them.
Okay. All right, let's see. Brittany, your mind is a steel trap.
No, actually, Bashan says she's.
Bashan, your mind, well, Bashan's mind is always a steel trap. We take it for granted. Because I was wondering why the dismissals were in here, because usually they're not.
It's usually better, from my standpoint, Judge, I guess, but yeah, I think there was just some confusion because we got recalled from Friday to Monday, but happy to be here, Judge.
Okay. Defense.
Yes.
All right, and are you ready?
Yes, ma'am.
All right, so we're gonna go back on the record. So state, were you able to make contact with the complainant?
We were not, Your Honor, as to this case. We did make multiple attempts beginning as far as January 7th of 2022. We did enter a clear request earlier this year in January 12th of 23 for further contact information. the information that was returned to our office. We made attempts at 3 different phone numbers and were unsuccessful in contacting the complaining witness in this case. We did make one further attempt February 2nd of 2023. Again, and send an email to an email that was returned to our office. And again, we were unsuccessful in contacting the complainant.
All right. And that's the reason why the court wanted to know, because the court had concerns of the nature of the offenses and the fact that an application was being approved by the state, but now the court understands the reason for the approval is that the complainant is no one's been able to contact the complainant.
Correct, Judge, and she does also have an active warrant for violations of bond for a DWI case. So she is listed as fugitive status as well. Sarge.
Okay. All right, Mr. Rodriguez, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right. How many children do you have?
I have 2 children, ma'am. I have a 18-year-old and a 5-year-old.
And who's the mother? Is the complainant the mother of either of these children?
No, it's someone I've been with for the past 13 years. The complainant, I just had started a relationship with her, and we were living together and stuff. And I had previously called the cops on her because she was assaulting me when I tried to leave before any of these cases happened. I did get a contact back from the detective asking if I was willing to press charges, but since everything was okay, I told the detective I didn't want to press charges. And after she got arrested from her probation officer by that, then this is where she continued to put accusations against me.
All right, how far did you go in school?
I went to the 11th grade.
Do you have your GED?
No, I'm actually going back to school as soon as I get out of here to San Antonio College. I tried to get
How old
my
are you?
GED. I'm 34.
All right, so why are you just now putting
No,
these?
I tried to get my GED and I went through the whole class to matter of fact, and I came up short on a little bit. So the whole COVID stuff happened. So it's kind of hard for me to get back into school.
All right, so where have you worked before doing what?
I remodel houses for a living. I've been doing this since.
And if you're released, who are you going to be staying with?
I'm going to be staying with my sister.
Does your sister want you staying with her?
Yes, I just talked to her yesterday.
All right, what's her name?
Roland Rodriguez. And my stepdad stays there as well.
Does she have children?
Yes, she had my niece, Cheyenne.
And how old is your niece?
Well,
All right, any drug use?
no, ma'am.
Here's the thing, if there's drug use, you need to tell me, because if they are, I'll have conditions of probation to help you with that.
Yes, ma'am.
But if you tell me they're
I
not,
have a drinking problem.
okay. How often do you drink?
I used to drink every day.
Well, let me tell you, while you're on probation, you're not allowed to drink alcohol,
Yes.
even at your own house. It's not allowed. All right, and each of the cause numbers, this is what the court will do. Court will sentence you to 8 years probation. I'm sorry, 8 years in the prison, suspended and probated for 8 years. Each case will run concurrent with the other. Take in consideration 2023 CR 0530, 2023 CR 0532. There's an affirmative finding of family violence. There's to be no contact with Hannah Barnes. That's Barnes. Proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. 200 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination with booster. Court is not requiring you to get that, but if you do, 40 of those hours will be waived. I'm going to want parenting classes with triple P. The remaining of the hours will be waived once that's completed. Do a TAP evaluation. If the TAP evaluation recommends inpatient treatment or outpatient treatment, I want to start with intensive outpatient treatment. The BIP course. Regular UAs and probation, if you can make sure they test for alcohol. Regular reporting by Zoom or in person. I'm going to want field visits 2 times per month until further notice. I'm going to want GPS partial for work and probation. Once he's on GPS partial for work, then you can taper off the field visits. And that GPS partial for work, we'll see how he does in 3 months. If all is fine, then that can be removed. Probation, is there anything else he needs? Is there anything you need from the court?
I was gonna ask you, ma'am, I work out of town. I go to Kerrville, Austin to remodel houses. I was gonna see if there's any way I can do a tracking to monitor instead
Oh,
of.
partial is for work.
But sometimes I stay out of town.
He's requesting permission to travel for work purposes, Judge.
You will have to speak with probation about that. I'm here Mondays through Fridays and probation will let me know.
Yes, ma'am.
All right, is there anything else from either side?
Nothing from the state, Your Honor.
Nothing further from the bench.
All right, in each of the cause numbers, did you sign a document entitled Trial Court Certification of Defendant's Rights to Appeal? And did you review that with your attorney and did you understand it?
Yeah.
All right, because these are plea bargaining agreements, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
And because these are affirmative finding of family violence, and also because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand?
Yes, ma'am.
Counsel. Oh, sorry.
Oh, no problem.
All right, we can go off the record. Good luck to you. You're gonna have to start making better choices. If you do not make better choices, you're gonna find yourself in and out of prisons. And I always tell people, sometimes we're not ready for relationships. I always tell people, get an orchid. If you get an orchid, when you get an orchid, it's beautiful. The flowers are there. It's great. Then you get it home. Once the flowers fall off, it's hard to get it to bloom again. I'm still working on that. So until you can get an orchid to bloom after all of the blooms have fallen off,
Yes, ma'am.
you're not ready for a relationship because an orchid requires patience. And you have to be kind to it.
Plan on keeping the relationship with my kids.
Yeah, that's it. Your children should be your number one priority.
Yes, ma'am.
All right, good luck to you.
All right,
Thank you, Your Honor. May I be excused?
Yes. All right, who is Karen Corby's client? What's your client name? All right, Mr. Smith.
Yes, ma'am.
Oh. So Miss Corby, what's happening with your client?
He recently had a heart attack. He got out of the hospital. End of last month. Apparently he's got all sorts of doctor's appointments. He's not doing well. His parents and brother brought him here today.
Okay.
I don't think he's prepared to go to trial today. We're just asking for a reset and I might be considering filing a motion for competency, but I want to get some information.
All right.
He is right there.
All right, so Mr. Smith, I asked your attorney to provide the court with medical documentation, and then maybe you will be excused. So if there are issues with your medical, you need to get a doctor's letter stating that you cannot come to court, and the doctor needs to provide the court with a reason why you can't come to court. Do you understand?
Yes, ma'am.
All right, Ms. Ferguson, let's recall this for 30 days. And Ms. Corby, if you think there needs to be a competency evaluation, it needs to be filed before then.
Thank you, Your Honor.
All right, which date, Ms. Ferguson? All right, after he signs the reset form, he's excused.
Thank you, Your Honor.
You're welcome. Who's here on Jonathan Nicholas?
I'm here, Judge.
All right, is this on the docket today or no?
It is not on the docket today. We were here last week. I was in a trial and kindly brought me up first. We were talking
Yes.
about the expert on the cell phone.
Yes.
So that is the motion I filed. It was under seal. So I thought, well, I have time today. Let me come over here.
Okay, no problem. So here's the thing. I know you're doing it ex parte, but how are you going to get it if it's ex parte? Because I mean,
I can rewrite it.
no. I'm just letting you know, it's going to be hard for it to be ex parte if you need to go somewhere to get the evidence. You see what I'm saying? It's sort of like if you want to test drugs and you say, I want it to be ex parte to testing other drugs. Now, maybe the results of it would be private.
Should I file this another motion?
No, I mean, you can, I'll let you doctor this one, but here's the question. Do you know if the state is handing that over, if there are some issues, because this is sensitive issues?
Yes, I talked to Ruiz Harrison last week, and she asked me if we filed a motion. I told her yes, I filed this ex parte.
All right.
If I did it wrong, please tell me.
Oh, no, because I think they need to know about it so they can hand it over. Ms. Ferguson, can you have Ms. Harrison come down?
Yes, ma'am.
I just want to make sure both of you are on the same page so that we can get you the information you want.
Thank you.
All right, just give us a moment. Caleb Ruiz. Who is the attorney here on Caleb Ruiz? All right, come forward. Vashon, this is no application. Court is calling 2023 CR 0122. You all need to be quiet in the box, counsel, or either you can move it to the end. Court is calling 2023 CR 0122, State of Texas versus Caleb Ruiz. Can I have parties announced for the record for the state?
That'd be Cruz on behalf of the state, Your Honor.
Defense?
Ron Zimmerman on behalf of Mr. Ruiz.
Are you Mr. Ruiz?
Yes, sir.
Counsel, have you received all the evidence in this case and did you review it with your client?
I believe so, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Ruiz, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it? And did you understand it?
Yes, Judge.
Counsel, do you waive the reading of the indictment?
Yes, we do, Your Honor.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
Mr. Ruiz, I'm showing you what's entitled Court Admonishments. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, Judge.
Did you understand you're charged with unauthorized use of a vehicle? That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Judge.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, sir.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Judge.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Judge.
Counsel, has your client been able to provide you with any defenses?
Yes, he has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe so, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Judge.
Mr. Ruiz, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Judge.
Has anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes,
Are you a U.S. citizen?
yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, Judge.
According to the plea, your punishment is to be assessed at 6 months in a state jail facility. The state will take in consideration 2023 CR 0121. Did you understand that to be the plea?
Yes, Judge.
Defense, is that the plea?
Yes, sir, Judge.
State, is that the plea?
Yes, Your Honor.
Showing you the paragraph entitled waiver repeal paragraph. Did you review that paragraph with your attorney? Did you understand it and did you sign it in both places?
Yes, Judge.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court.
Yes, Judge.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest, Judge.
State any evidence?
At the time, the state introduces state's exhibit number 1 and all of its attachments.
Any
No
objections?
objection, Your Honor.
Mr. Ruiz, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Judge.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Judge.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Judge.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and state your excuse. After reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will find you guilty or proceeding with sentencing.
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Yes, Your Honor. Mr. Ruiz does understand the gravity of his situation and the gravity of his offense, of the offense that he did commit. And he would ask the court that the court approve of and enforce the agreement.
All right, the court will follow your agreement, sentence you to 6 months in a state jail facility, give you credit for any time served. Showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, Judge.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Judge.
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Judge.
All right, good luck to you. You're gonna have to do better. Otherwise, you're gonna be in and out of prison. And what are the chances you steal a vehicle and then it ends up stalling and somebody comes to help you and it's the police? If you want a vehicle, you got to work for it. Otherwise, take the via bus. The transportation is okay. All right, good luck to you.
Thank you, Judge.
One thing further, Your Honor, does the agreement or the sentence include time and money to run concurrent?
Yes. All right, thank you.
Thank you, Judge.
All right, who's here on Paul Donaldson?
Present on that, Your Honor.
Yes. Hello. Yes. So on this case, let me see if I can find him on the docket.
It was set, yes,
Okay.
Judge, it was set last Thursday. I was in federal court in Del Rio, so the court recalled it for today. There has been an offer tendered that has not been accepted.
All right, see you tomorrow.
Your Honor, we have two experts in the case that I need to give notice to.
Who needs to give notice to?
I need to give them notice of the date.
All right, tell them to see him tomorrow.
Your Honor, I don't believe that they'll be available on such short notice. They usually would require at least.
Well, let's
30
see what
days.
happens. Okay. All right, thank you.
Sure.
Donaldson.
Ignacio Rios. This is you.
Yes, I should have that. That's 3 in a row, Judge.
All righty. So what is happening here?
Mr. Rios, there was some last time discovery issues. The state uploaded it. So I believe we have everything. An offer was tendered today. That Mr. Rios is considering.
He did want just a little time to consider that offer, but we do believe we're moving towards a resolution in the case.
All right, how old are you, Mr. Rios?
28.
All right, thank you so much for dressing appropriately for trial. We'll see you tomorrow. Let me know whether or not you're accepting the state's offer, okay? Thank you. Ms. Ferguson will give you a reset form. Michael Montoya, are you just
Last
like?
one. They were all set on the same day.
Find Mr. Montoya on the docket, just a moment.
He should be an add-on as well. If that helps.
All right, what is happening with Mr. Montoya?
Judge, this one was set for, again, last Thursday for plea deadline, that was moved to today. We had tendered the state some documents. They did make an offer today. The offer, has not been accepted. Again, Mr. Montoya would like some time to consider. Today was the first offer that had been made. And so we are asking for a reset. If the court would like to set it for trial in the future, obviously. But
All right, Mr. Montoya, how old are you? 21? All right, Ms. Ferguson, recall Mr. Montoya at the end of the month. All right, your plea deadline date is March 30th.
thank you, Judge.
All right, thank you. Dean Villarreal. Sorry, I'm just finding him on the docket. All right, what is happening with this case?
Judge, I'm going to confirm with the state, we are lacking some discovery. Some of it has come in, I believe, this morning, but then Brittany and I need to kind of get together because we don't know. There's some medical records that are lacking that came in, but we don't know what time frame they covered. There's some other things that are lacking.
All right, so what is the discovery that's not there yet?
I don't know, it's just the sexual assault exam.
Okay.
Records, I don't know what other.
So there's the file reflects a history of mental health issues with the complainant. It reflects medications, it reflects.
All right, and is Chopper Services involved in this or no?
I can't tell from the file.
I believe, yes, there's a little bit of CPS records that was included with the filing, but I do think we'll probably need to request the full record.
All right, and CPS may have the information that you're looking for.
Yes.
Ms. Ferguson, on Dean Villarreal, can I have a 30-day reset for discovery?
Yeah, April 7th.
All right, we'll be back on April 7th for discovery.
Thank you, Your Honor.
You're welcome.
Have a wonderful day.
All right, thank you. You too.
Thank you, sir.
Ralph Delgado. Okay, thank you. Patricia Perez.
Yes.
All right, if you come forward. All right, Ms. Abrams. On this case with Ms. Perez, do you think it's best that she be transferred to Kendall County?
Yes, Your Honor.
All right, so even though you're going to be transferred to Kendall County, what will end up happening if you don't follow the rules there? A motion to revoke will end up being filed and it'll come back to the court. Do you understand?
Oh, definitely.
All right, so do you have plans in place so you can be successful?
Yes, ma'am.
Okay. All right, probation. How is she being monitored with regards to any alcohol use?
Let me double check, Your Honor.
Are you on any type of device for alcohol testing?
Well, no, I don't know if this is. So remember, I was supposed to have this for a month, but I've had it for like 120 days now.
Oh, yeah. I mean, the reason why you've had it for that time is because you have not been following the court's rules. So is she on any type of alcohol monitoring?
I'll be like,
Because she was the person who had some issues with a vehicle at her house. It was her ex-husband, maybe not her ex-husband.
Your Honor, just give me 1 second.
Okay. Because I had on here ignition interlock for half the term. All right, so she needs to, if she's going to be supervised in Kendall County, she either needs a portable device, but she needs a alcohol monitoring device.
Yes, Your Honor, so if. My understanding, based on the report, the car that was at the residence was towed.
Yes,
So if there are no vehicles, you want her to do the portable handheld device and
Yes.
an affidavit of non-driving.
yes.
Will the only thing that's hindering.
I mean, will Kendall accept her? I mean, can't we order for Kendall to give her that?
I mean, yes, it'll be in our conditions, but I'm saying as far as the field visit is concerned, to confirm all of that. Because it's in handle that. We won't.
So you won't be able to do field visits. All right, so yes, so I want her on that sober device then.
Okay.
All right, is there anything else?
Did you want her to remain with the GPS?
Is she able to remain with GPS and be in Kendall County?
Yes, Your Honor, I mean, it's the.
All right, so she's to remain on the GPS device until she's on some type of alcohol monitoring device.
Okay.
Anything else?
No. And Your Honor, I just do want to point out, whenever, because of the offense, whenever she does submit her urinalysis, we do make sure that she is tested for alcohol.
Okay.
Okay.
All right, thank you. Anything else you need from the court?
No, I'm not.
All right, thank you. All right, Mr. Delgado. Ralph Delgado. All right, and what is the issues with Mr. Delgado?
Your Honor, the issue is, he failed to report in December. He has not gone to the intensive outpatient treatment. There was 2 set up for him and he just didn't go. The monthly UAs have not been submitted regularly. And the last submission was back in October, Your Honor. The sober support meetings, he says that he's attending, but there's no proof of that.
All right, Mr. Delgado. You're looking at 1 year in the state jail facility. How old are you?
68.
All right, you're 68. I noticed that you have a cane. And I understand that people have issues. But when you commit an offense, there are consequences for it. And the consequences are not, I'm not going to follow through with my consequences because I have these other issues. So you're going to have to follow through with probation. Otherwise, you're looking at 1 year in the state jail facility. And what I can tell you is there are people at the prison who are in wheelchairs because people are like, okay, you're in a wheelchair. They'll make arrangements for you at the prison. So regardless of your age, they will make arrangements for you at the Bexar County Jail, and they will take you to the state jail facility. I don't know how they'll allow you with the cane, but they'll make accommodations for your frailty. Do you understand? So why are you not following through on your conditions of probation?
Most of it is misunderstanding on my part and possibly due to my memory. Like a couple of those where I didn't get a UA. I just have to figure out that day to do it. So what I did was I went to put another UA at another day. And my officer told me that he didn't want me doing that. Only when he found me, so that's why I just UA.
Well, here's your thing.
The Zoom thing that I was supposed to do for the outpatient thing. I couldn't get my Zoom working because I'm not that computer literate or phone.
All right, so that means that you're not going to be doing Zoom anymore. You're going to be reporting in person.
Right.
You understand? I'm notating on this docket sheet that we've had this conversation. I'm not going to accept any more excuses. We're not going to have a conversation like this again. What's going to end up happening is a motion to revoke will be filed. And when that motion to revoke is filed, if it's in proper order, I'm going to sign it. Somebody's going to come to your home or wherever you may be. They're going to arrest you. Either you're going to make bond or not. And then if you make bond, we'll hear the allegations. If you don't make bond, we will hear the allegations, but you'll be dressed in orange, brought over from the Bexar County Jail. And trust me, the deputies will have your cane in the back. And when you need it, they'll give it to you to walk to and from the box. So you understand? There are consequences for actions, and you have broken the law. You've been placed on probation, and you need to report to probation. Do you understand? All right. Is there anything else he needs? We're not going to have this conversation again. You understand? All right. Thank you.
Bernard, so I'm sorry, did you want me to amend conditions for him to report in person?
Yes.
And then all other conditions remain, correct?
Yes. Ways. So they're not pleading on, they didn't go for it on the enhancement. Oh, I'll put it in there.
First row.
Because it wasn't in the steps. Mark Anthony Salcedo. All right, and this is where the state was reaching out to the complainant.
Yes, they do.
All right, state, were you able to get in touch with the complainant?
Judge, I'm not aware. I know that case of Aaron Hanks coming back.
Okay, all right, just give us a moment. We'll call you back up. Margaret Ann Roberts.
Not here, Your Honor.
All right, Miss Ferguson. Let me see. Okay. All right, Norma, can you recall this for tomorrow? Could you let her know her attorney's in Wilson County? Who is here on Donald Stockton? All right, Ms. Abrams, this is no application. Court is calling 2022 CR 6268, State of Texas versus Donald Stockton. Could I have parties announced for the record for the state?
Brandon Jackson for the state.
Defense,
Eric Hernandez for the defendant, Donaldson.
are you Mr. Stockton?
Yes, ma'am.
Counsel, have you received all the discovery in this case and that you review it with your client?
I have another.
Court will find that the state is in compliance with discovery. Mr. Stockton, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We waive.
State, are you proceeding on the indictment as presented?
Yes, Judge, we'll be proceeding solely on count one, and we'll waive and abandon the rest, including the enhancement paragraph.
Okay. Any objection?
No.
Mr. Stockton, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it and did you sign it in all the appropriate places? Did you understand you're charged with the offense of theft, 30,000 to 150,000 elderly? That's a second degree felony. The range of punishment is anywhere from 2 to 20 years and up to $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent? Did you understand by entering this plea bargain agreement, you were giving up those rights? Did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe so.
Do you believe he's currently competent and was legally sane at the time of the offense? Mr. Stockton, has anyone threatened you, forced you, or placed you in fear to get you to enter this plea? Has anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? Are you a U.S. citizen? Dismissal.
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial, showing you the plea bargain page. Did you review that page with your attorney? Did you understand it? According to the plea, state is proceeding on count one. Punishment is to be assessed at 4 years in the prison. There's a $2,500 fine, no applications. The state will take in consideration 2022 CR 6267. Did you understand that to be the plea?
Ma'am.
Defense is at the plea?
It is, Your Honor.
State is at the plea?
Yes, Your Honor.
Is there any restitution, state?
There is, Your Honor, but not to the victim. It would be payable to the banks that are concerned, Cross Bank. And in this case, we understand that jail time will probably satisfy. So,
Don't go understand Your Honor, but then we're going to confirm with the same.
All right, so y'all are not asking, usually restitution doesn't run concurrent. Because people don't get paid because he's at jail. So if you all are not requesting restitution, then the court is not going to order it.
I can put it on for the judgment purposes, but I think that usually, once they go to prison, it can get satisfied out.
No. Mr. Stockton, my understanding of the law and the way it works is once restitution is given, if let's say your restitution is $200, if you end up making parole will say that you owe $200 restitution. So are you all saying there's no restitution? Is anybody asking for restitution or no?
Not the victims, but the banks are asking for restitution.
All right, then the banks will need to handle that on their own. All right, unless you all want to put it in the plea bargain agreement.
I mean,
It wasn't part of the plea bargain agreement, Your Honor. I agree, it could be a civil matter on the insurance parties.
I mean, it's completely up to you all with regards to the plea.
if you wouldn't mind if we put it in there for the judgment purpose, but I believe that it'll be, unless he's on parole, that's the only reason I can come in.
That's fine.
Oh, you all want to agree to a restitution amount?
Yes, sir. The rest is going to be, when we put it in the.
Yes, if you all want to sign that. All right. All right, and also as a part of the plea bargain agreement, there's to be restitution of $49,850 to Frost Bank. Did you understand that to be the plea? Defense, is that the plea? State, is that the plea?
Yes, ma'am.
Showing you the paragraph entitled waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, there be any such motions?
No.
Then to the offenses charged in count one, how do you plead? Guilty, not guilty, or no contest? State any evidence?
This is the state without the exhibit one with all attachments.
Any objections?
No.
Mr. Stockton, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine any witnesses the state would call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. Court has reviewed the same. Court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, ma'am.
Anything you wish to say on behalf of your client?
And no, Your Honor, other than you can accept responsibility for that.
All right, the court will follow your agreement. The court will sentence you to 4 years in the prison, give you credit for any time served. Take in consideration 2022 CR 6267. There's to be restitution to Frost Bank in the amount of $49,850. Showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that with your attorney? Did you understand it, and did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand? Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, good luck to you. Don't steal, it doesn't pay, okay? Thank you.
Thank you, Judge.
Who's here on Abel on Ornelas? And when you all are ready, if the state is, okay. Well, I've been here since 8, so, you know. All right, Abel Ornelas, what's happening on this case? And I show that you have all the discovery.
Yes, Your Honor.
All right, Ms. Ferguson, I need a 30-day reset for a plea deadline date on Mr. Ornelas. All right, we'll be back on April 7th. At that time, you need to let the court know whether or not you're accepting the state's offer. If you choose not to accept the state's offer, the court will not consider any plea bargain agreement without good cause. Otherwise, you have to plea open to the court. Do you understand? All right, thank you. You're welcome. All right, Ms. Chacon, what's your client's name?
Mark Salcedo.
Okay. All right. So what is happening with Mr. Mark Salcedo? We were here for the state to reach out to the complainant.
At this point, Your Honor, sorry, I'm just dealing with it today.
Yeah.
But my understanding is the complainant has not been, I guess, reached.
Mhm.
So to confer with defense counsel, I think we're just asking for, she's going to supply me with an email,
Mhm.
possibly from the victim in this case. And we're going to follow up with that. I think we're just asking for a short reset for us to be able to do that. She's the first of the 2 weeks, if the court will allow that. And I believe that it might be able to get handled that way.
All right, Ms. Ferguson, can you put Mr. Salcedo at the end of the month? And then if it's not needed, it won't be needed.
Yes, Your Honor.
What date? All right, March 30th.
Thank you.
All right, thank you.
Ornelas?
Francisco Reyes. Who's the attorney on Frisco? Yes. All right, so where are we on some body cam videos, photos needed?
Your Honor, the body cam videos were received. Setting.
Okay.
So we're good on that. We're still battling out on figure dismissal coming down to one or the other. I have now conferred with Mr. Garahan. Mr. Jordan's, I think, is in trial. I would ask the court to recall us on Thursday, and we will either plea that day or.
Well, I will not be here on Thursday.
You're not?
No.
Well, the issue is, Your Honor, that Mr. Reyes has been on a GPS tracking for 3 years. The state's not in agreement, or for 6 months, I'm sorry. When you got the next.
All right, we can call you back for Thursday.
Okay.
All right, we'll see you back on Thursday the 9th. Ms. Ferguson will give you a reset form.
Thank you.
You're welcome. Who's here on Margaret Roberts? Margaret Ann Roberts. Oh, that's recalled for tomorrow.
She's here. She just got here. No, not her. I'm Margaret Annette, sorry.
That's okay.
I'm getting my people confused, Judge.
Mark Anthony Solomon.
President Council.
Thank you.
Thank you, Your Honor.
All right, thank you. And there's no application.
No.
Okay. I just announced it, so probation to know. But thank you for verifying. Okay. All right. Court is calling 2022 CR 9125 State of Texas versus Mark Anthony Salmon. Can I have parties announced for the record for the state?
Brittany Mitchell for the state.
Excuse me, Mr. Sekwanowicz. You all need to move it on the other side. We're on the record. All right. Could I have parties announced for the record for the state?
Brittany Mitchell for the state.
Defense?
The attorney record is Joanne De Hoyos. Joseph States, and I work with Mr. Hoyos. Mr. Saman, did you give this?
All right, Mr. Salmon, I'm showing you, I'm sorry, counsel. I'm showing you the discovery acknowledgement. Have you received all the discovery and did you review it with your client?
Yes, sir.
Court will find that the state is in compliance with discovery. Mr. Salmon, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yeah.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, sir.
Mr. Solomon, I'm showing you what's entitled Defendant's Waivers and Affidavit of Admonitions. Did you review that with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes.
Did you understand you're charged with assault family second offense? That's the third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yeah.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yeah.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yeah.
Did you understand by entering this plea bargain agreement, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case?
Yeah.
Counsel, has your client been able to provide you with any defenses? Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent, was legally sane at the time of the offense?
I do, Your Honor, and just so you know, we previously filed a psychoval motion. He was found competent by Judge Carruthers on January 26th of this year.
And Mr. Salmon, has anyone threatened you, coerced you, or placed you in fear to get you into the plea?
No.
Has anyone promised you anything other than the plea?
Ma'am.
Are you satisfied with the way you've been represented?
Huh?
Are you satisfied the way you've been represented?
Oh, yes.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial, showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes.
According to the plea bargaining agreement, punishment is to be assessed at 3 years in the prison. There's an affirmative finding of family violence, and there's to be no contact with Imelda Salmon. Did you understand that to be the plea?
Yes.
Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition? And did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes.
Did you understand that to be the entirety of your plea?
Yes.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Your Honor.
Showing you the paragraph entitled waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
Other than the second, no, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
State exhibit number 1 and all attachments.
Any objections?
None.
Mr. Salmon, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept in evidence states exhibits 1 and attachments. The court has reviewed the same. The court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are we proceeding with sentencing?
Yes, Your Honor.
Court will follow your agreement, sentence you to 3 years in the prison, give you credit for any time served. There's an affirmative finding of family violence, and there's to be no contact with Imelda Salmon. Showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that document with your attorney? Did you understand it, and did you sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction and also an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. Do you understand? All right, good luck to you, Mr. Salmon.
Okay.
Always great seeing you.
Thank you, Judge. Nice to meet you.
All right, thank you. Javon Crockett. Who's the attorney on Javon Crockett? All right, what's happening on this case?
We've received an offer from the state, and talked to my client about it. He wants to face his accuser.
Do you have all the discovery?
I have all this stuff.
All right, state, if you could do an acknowledgement of discovery, please. All right, Ms. Ferguson, can you reset this for 30 days for a plea deadline date, please?
April 7th.
All right, we'll come back on April 7th. At that time, you need to let me know whether or not you're accepting the state's offer. If you choose not to accept the state's offer, the court will not consider any plea bargain agreements without good cause. Otherwise, you have the plea open to the court. Do you understand? All right, thank you. I'm sorry, April 6th. All right, Norma, we've said some other cases on the 7th.
Yeah, I changed one of them to the 6th.
All right, that's Ornelas. That should be changed to the 6th. Okay. That's fine. All right, and then who else do we have left? All right, we have Mata. What's happening on Mata? Okay. And then we have Ronald Keith Collins. All right, I need to see that file. And I need to see the file on Mariah Rodriguez. Sarah Espinoza.
If you know, I just arrived.
All right, just give us a moment. Are those the only cases remaining, Caroline?
Your Honor, we sent that, Gaspar Rodriguez.
Yes. All right, Norma, on Gaspar, we need to, if you could speak with, managed assigned counsel, because my understanding is Joe Richardson is asking to be removed, so tell managed assigned counsel. All right. Okay, and then, Jason Lopez. Did Jason Lopez show? Yes, he did. Okay. All right, and that should be it. Do we have any other files over there, Caroline?
Just the Mata.
All right. So on Jonathan Nichols
Yes, ma'am.
or Nicholas?
Oh, that's good.
Yeah. All right, so,
But I was in contact with him Alex last week and asked him about the ex parte, I asked him about the motion, and he informed me that he filed an ex parte motion. And I stated to him that, let me know what the court decides, and I need to find out when, because you have to go through me in order to get to the evidence.
well, that's why I was explaining
Yes.
that I don't know if ex parte is appropriate, because then that means nobody knows about it.
Yeah.
And well, which of course, there can be some things that people are not allowed to know about, but the exchanging of evidence.
I understand.
So if you all want to let me know who, when, what, where, the court will, sign for your expert to view or whatever your expert needs to do.
That's what, and I just told Alex, I need to get the information from him so I can get, Sergeant O'Neill's waiting. I told him about it. I just need to get the experts' information so we can schedule a time for him to come get the
All right.
get the evidence.
So I will sign. Have you reviewed the motion?
No, I haven't
he
got it.
wanted she wanted us to look.
I mean, do y'all not see that?
I got it.
I'm like. He's a little taller, Judge.
Go ahead, laugh. It's all right.
No, there'll be no laughter.
I feel like
No, no, no. So y'all want to step back and confer
ma'am.
over that.
thank you, Judge.
And then on Sarah Espinoza, that was a no-show? Huh? All right, come forward. Why were you late?
My uncle was supposed to watch him for me, but he never came this morning, so I had to actually have a neighbor.
All right, let me ask you this. What would happen if I drug tested you right now?
Oh, you could go check me, that's fine. That's why, the last time I was here, I wanted to get a different, attorney because he was saying that I wanted to get me probation.
No, here's the thing. I want to hear I don't need to hear what the offer is.
Okay.
So who is your attorney?
David Taylor, he never answered my calls, he never, called me.
All right, so we're going to recall you for tomorrow.
Okay.
Mr. Guevara was here early in the morning to actually looking for her.
Yeah, he was.
Well, I definitely, I have it on my.
So here's the thing. No, let's not do that. Because here's the thing, you were supposed to be here at 9. Your attorney was here, you were not here. So we're recalling you for tomorrow and you will be here at 9. If you're not here at 9, what's going to end up happening is a warrant may be issued for your arrest. And if it is, we'll make sure that you're on time because they'll be bringing you over from the jail. You understand? So Ms. Ferguson, on Espinosa, we're recalling that for tomorrow.
Yes, sir.
All right, Ms. Ferguson will give you a reset form. I'm going to notate that you were late.
Is there any possible way I can maybe get, a good.
You can hire one.
I can't believe it's an important one because.
You can hire one. That's how you get your selection. You can get whatever attorney you want, but in order to do that, you need to hire one. All right.
Have a seat, I'll call you up.
All right, and then we have Mariah Rodriguez. And that is one who didn't show. Let me see who her attorney is. All right, Norma on Rodriguez. Can you let manage assigned counsel know that we need an attorney, because my understanding is Sonny Middleton is no longer practicing defense. I could be wrong, but someone said that maybe she had an employment elsewhere. So let's recall that for tomorrow and tell manage assigned counsel we need someone here. And then Ronald Keith Collins. Where is that on the docket? All right, is there a prosecutor available? Court is calling 2022 CR 11290, State of Texas versus Ronald Keith Collins for the state.
Jason Deerhand, Your Honor.
All right, this hearing was scheduled at 9 a.m. It is now 12:51 p.m. The defendant did not present himself in court. Defense counsel was present earlier in the day. Deputy Lord, did you make an announcement outside?
Yes, Your Honor, there's only one person, and that was not Mr. Collins.
All right, state.
State's requesting a bond forward, Your Honor.
All right, that'll be granted. He'll be remanded without bond. If he presents himself, the court will reconsider.
Thank you.
We just have this plea, then we're done for the day. That's my understanding. Yes,
Maybe Chris,
yes, you may.
yeah, let me go around over here.
People always want to go through that. I don't understand why.
It's the straightest
Straightest
line
line.
between 2 points, right?
All right, so you all in it, state you're in agreement in this?
Yes, Your Honor. And just let you know that I just emailed Sergeant O'Neill with the AG's office to give him the information for the extra ones.
All right, so I will see you all back on March 21st.
We are already set on the 23rd, Judge.
I have it down as March 21st.
You have it down as March 21st, okay.
Ms. Ferguson, can you check?
I would need to get some protection. I don't have
It's 2020, I'm sorry, 2018 CR 3520W. I have it on the docket sheet as March 21st.
The system says the 23rd.
All right, well, who's overriding what we put on the docket? That's what I'd like to know. Because it's clearly March 21st, and I just don't pull dates out. All right, we'll see you on March 23rd.
All right. Thank you, Judge.
Thank you. And if you want a copy of your order, just ask. Hi, if you want a copy of the order, just ask the clerk. Okay,
I'm glad to go get that.
all right, thank you.
Thank you.
Thank you.
You're welcome.
I'll check it out.
Well, look at here, we may be done before 1:30. Wasn't that our thing, our Festivus 1:30?
Yeah, sure. Yeah.
Denise, I saw your son's photo.
Which, yeah, both of them, yeah.
Yes.
19 years difference. The oldest one loves his little baby brother.
But see, that'll give him a chance to do so much now because he can appreciate, that'll give him a lot of chance to do something with his little brother.
He actually said he wanted to get with the doctor about a vasectomy.
Oh, well,
He was like, yeah, I think it's good. I definitely know I don't want to have kids now.
well, that may change.
Yeah, and then he said the laws of the United States and how's that going? Nah, he needs to make sure he protects himself.
All right, court is calling 2022 CR 10884, State of Texas versus Armando Mata. Could I have parties approach and announce for the record for the state? Defense? Are you Mr. Mata? Hello, are you Mr. Mata? Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case and did you review it with your client?
Yes, sir.
Court will find that the state is in compliance with discovery. Mr. Mata, I'm showing you what's entitled Application for Community Supervision. Did you review that document with your attorney? Did you understand it? Did you sign it? Next, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places? Counsel, do you waive, I'm sorry, not sign. Counsel, do you waive the reading of the indictment?
Yes, sir.
State, are you proceeding on the indictment as presented?
Your Honor, we are waiving count number 2 and proceeding on count 1 and the repeater allegation.
All right, I'm going to show you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Correct.
Well, that's either yes or no.
Yes.
Okay, thank you. It's a little bit late in the day. All right, did you understand the offense that you're charged with in count number 1 is possession of a controlled substance, penalty group 1, 4 grams to 200 grams. Normally that's a second degree felony. The range of punishment would be anywhere from 2 to 20 years in prison and up to $10,000 fine. State is proceeding on the repeat enhancement allegation. If evidence is presented to the court, then the range of punishment may be anywhere from 5 to 99 years or life in prison. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea, gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent? Did you understand by entering this plea bargain agreement, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Judge.
Mr. Mata, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Has anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it? According to the plea, state is proceeding on count 1. There's to be punishment assessed at a cap of 7 years in the prison. There's no application for deferred adjudication. State is silent on your application for community supervision. They will take in consideration 2022 CR 10885, County Court Cause number 692603, 692604, 692605. Did you understand that to be the plea? Defense?
Yes, Judge.
State?
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in all the appropriate places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, are there been such motions?
No, Judge.
Then to count one in indictment, how do you plead? Guilty, not guilty, or no contest?
No contest.
And with regards to the repeater enhancement allegation, how do you plead? Guilt, true or not true?
True.
State any evidence to support the defendant's plea?
Your Honor, at this time, the state introduces state's exhibit number 1 and all of the attachments.
No objection, Judge.
Mr. Mata, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that with your attorney? Did you understand it? Did you cite it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports and laboratory reports, but most importantly, there will be no live testimony. Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will find you guilty. The court will find the enhancement true based upon your plea or true and states exhibits 1 and attachments. We'll come back on April 24th for sentencing. The court will make its decision on your application based upon any evidence that's presented to the court and the PSI report. Is there a TAP evaluation needed? I mean, does he have a drug issue? I don't know.
Right, that would be helpful, Judge.
All right, probation, it'll be a PSI and TAP eval. All right, thank you. You may be excused. All right, guys, we are done for today. We'll be back tomorrow at 9 a.m.